Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican priest,
Is that correct?
Literally not true.
I didn't ask you to interrupt me. Oh, for Trump's sake.
Good morning, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Happy Monday to you. It's early. It's like an hour early for me. I am feeling this daylight savings change. It's killing me. It's terrible. Let's see. Where's my volume? Test 1 2. Test 1 2. That's not it. Test 1 2. There. It's a little hot. Check 1 2. All right. Nice goat. Thank you. I have a goat to show you. Valhalla awaits. Look, I finished it. This is 2,403, 2,404 if you count the back, pieces of Lego. And this is what your thumb looks like if you try pushing them all on within a 24-hour period. My fingers are killing me. But I made a goat. This is Valhalla Awaits logo for his YouTube channel. His little profile pic. And as a thank you for the invite onto his show, I did make a goat. I did finish it after the fact because apparently I can't build at a rate of 13.8 Legos per minute when I have to map them out like this. And I have another confession. I got to about 2,000, maybe just under 2,000 of these on, and my fingers were screaming in pain. They were going to bleed. It hurt so badly, and I had to give it. I had to call my kids in. Between the three of them, they finished the design for me. So it's all done. I wanted to show it off officially. It's beautiful. Here, I'll give you the close up view. Ready? Check this one out. I mean, look at the detail on this. Each one of those pixels is a different piece. All of them just one square. They're all the same size. One little five. Let's see. We've got white, light gray, dark gray, and black. I didn't use any of the yellow, so I still have 900 of those I haven't used. Almost ran out completely of white. That's all we had left over. So almost perfect that way. And now comes the fun part, because my kids want to build something on here. They want to do their own mosaic. They haven't chosen the picture yet. But to get that to work, they grab this little orange tool that's in this bag, and you take it and you push it on the edge, and then you bend it, and it lifts 2 of the bricks up. They have to do that like, I don't know, what is it, 1,200 times to get all these lifted off and then sorted. But that's their project. And good riddance. Oh, my goodness. I loved it. I actually loved it. I loved it. Have them do a zebra. Oh, that would be cool. I don't know. They're going to choose. They're making their own. They're going to the Lego website has a mosaic maker where you can upload a picture and you can sort of choose a picture and it will convert it into a map for building a Lego picture like that. So good fun. All right. No, you need to send it to Valhalla. No. He doesn't want this. He's got the actual goat. And my kids have been begging to use it. My kids would disown me if I mailed this to somebody. Plus, I love this set, but I'm worried it's going to snap. It's just, there's so much weight from all these pieces on it that I'm worried that if you pick it up wrong, it's just going to snap in the middle. And I don't think it would survive shipping unless I crated it. It's going to keep them busy. It's like diamond painting. Yes, it is. Have to take a minute here and turn the buttons on. Oh, no, not that one. There we go. Lindsay Bay, first in chat today. Lindsay, congratulations. I know you said this was just pure luck. You just turned it on and boom, there we were. But you were, in fact, first in chat. And congratulations. And also, I'm sorry. I'm sorry in advance because we're going to punish you. We're going to make you internet owner for the day. You're responsible for IP problems across the world. Whatever, whoever, wherever. If there's a problem and it's connected to the internet, it's also connected to you now because it's your problem to fix it. So congratulations, Lindsay. Thank you for doing this for us, though. Somebody has to do it. And today, it's your day. It's like jury duty. You've been sort of chosen when it comes to that. You're going to do great. Have you seen the solar system one? Yes. That one is infinitesimally harder because I'm not sure if that's a word. Infinitely harder. Let's use that one. Because instead of just having little one square blocks, they also have little slants and different size pieces. That's like a 10-hour build. All right. Post office run. Am I allowed to open it? I got a text from Amber. He was like, "Hey, I sent you something." I'm like, "Oh, cool. I'm excited. I'll run to the post office." She's like, "Don't open it." I'm like, "What? Do you regret sending it?" You're like, "Return to sender." Is there something I shouldn't see? Were you mad at me at the time you mailed it and now you're not mad? And you're like, wait, I take it back. I don't know what she's done, honestly. But she's just like, "Don't open it." I was going to tell you, Amber, I don't open my mail. I have people that do that for me. They're called kids. My kids open my mail before I get it. They're like, "Ooh, Dad got something. What is it?" And they open it. So if it's a problem, if it's a snake, let me know because I need to warn them. So anyway, good morning. No, they can't open these. Okay. I won't take them on this mail run. All right. How is everybody doing? How did everyone survive the daylight savings shift? Some of you are like, "That's why you're on early." Yeah, we lost an hour of sleep over the weekend. And honestly, between being up on the podcast with Valhalla Awaits, I ended up, part of the problem was I drank like a Mountain Dew at 1 a.m., which is probably not a good idea. Looking back in hindsight, I've got to open them live. I drank a Mountain Dew at 1 a.m., and so I didn't go to bed till 3, which would be fine, other than the fact that I was live streaming a gig that I had to be there at the venue at 8 in the morning. And I had not done any prep for that one. And so yeah, that was fun. But let me tell you, over the weekend, Friday night, we went to that.
Happy birthday.
Thank you.
You look good.
Oh, yeah, we'll do that right now. Let's do the birthday things, and then I'll tell you all about my weekend, which you probably don't want to know about, but I'm going to tell you anyway. All right, let's see. Colleen, Itchy Withers Rescue, is celebrating their birthday today with us. That is awesome. So, and Brittany Bell. Can you add Brittany Bell? If somebody can just put both these names in a chat. Doesn't matter who. I just need both of them in one chat so I can see them. Otherwise, I will not be able to find them. Let's see. I'm waiting. Still waiting. All right, here's what's going to happen. I'm going to try to see them both. We'll try. Everyone take a deep breath, stand up, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, warm up with me if you will. La 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 la. There we go. All right, we're going to sing to these three wonderful people. Colleen, Brittany Bell, and Ayden Stanberry. Happy birthday to you. Happy birthday to you. Happy birthday, dear Colleen, Brittany Bell, and Ayden Stanberry. Happy birthday to you. 3 wonderful birthdays for a Monday. That is wonderful. That's not bad. That's not bad. 3's a good start for the week. Happy womb evacuation day to all those celebrating. Colleen, Brittany Bell, and Ayden Stanberry. I realize there are a million places you could be, a million people you could have chosen to be with. You chose to be here with us to celebrate here on the channel, live, most of you. And the privilege, the pleasure, the honor of that, being selected by you, is wonderful. Hopefully we can return part of that back to you and make your day a little more special. Help yourself to free pancakes at Denny's, IHOP, Village Inn, McDonald's, Waffle House, Tammy Dunlap's house, Bob Evans, and Andy's Grill. It's Mario Day. March 10th is Mario. It's a me, Luigi. Didn't know there was a Mario Day. It's time to do the Apple Dance. What's the Apple Dance? The Apple Dance is what I do when I'm going to go buy another Apple product. It actually looks like a limp because I'm carrying all the cash with me to pay for it. And it's heavy because they're so expensive. Today's the 40th year anniversary of my first date with my hubby, says Red Pen. Congratulations, hubby and Red Pen. That's awesome. 40th anniversary of first date. My first date with my wife, I took her fishing. On closing day of deer season. I kid you not. Closing day of deer season. I had a deer tag. I did not take my rifle with me when I was hunting, when we went fishing. And as we're hiking up there, I saw so many deer. It was crazy. It was crazy. Anyway, big finish with the drum solo. Ready? Help me with it. Beautiful, beautiful. Thank you all for your help with that. Yeah, I saw no deer, 0 deer during, hiking all over the place. And then once I went up in the evening with my wife without my firearm, so I could not shoot anything, there they were, littering the hillside. Just crazy. So that's how it works. I've never shot a deer. I've gone deer hunting many a time, but I've never shot a deer in my life. I'm quite possibly the world's worst hunter. If I was a caveman, I would not have survived. We would be very hungry. Let's put it that way. All right. Amber's calling, but I don't know where I put my cable, so I can hear her and you can't. Amber, are you there?
I'm here.
Oh, now they can hear you too because you're on speaker. What's up?
Well, hello. 2 things. When you eventually get to the post office, there should be 2 packages from me, and you will know they are from me based off of how they are addressed to you.
Sounds ominous. Okay.
And you do have to open them on stream. They're early birthday presents.
Oh, it is my birth month, so that would be entirely appropriate.
It would be appropriate.
All right, open them on stream.
Everything is safe. Everything is safe. The kids safe everything, but they can't open it for you. You got to open it on stream. You're
going to have to tell them that because I tell them this all the time. And I'm like, no, please wait, please. Nope. It's like, does anyone know where the package went?
Okay. Compromise. The kids can help you open them standing off camera. You're right.
All right.
And
Tell you what.
Hand you the next item.
maybe if I give them the Mosaic Lego set so they can use that now, then I can compromise and say, in return for you guys getting this and being able to take it apart and play with it and do whatever and leave them on the floor so I can step on them. In return, you can't open my mail this week.
Well, at least the 2 that you know were for me. At least those 2.
Are there more?
They don't say Recovery Addict.
Great. All right. I'll run to the post office on lunch.
The name is also kid appropriate.
That I appreciate. All right, Amber. Thank you very much.
The second thing, hang on, I had 2 things.
Okay.
The second thing is because it's Mario Day, I have to tell you a dad joke.
All right.
Are you ready?
No. But go ahead anyway.
What are Mario's overalls made of?
What are Mario's overalls? Something flower power. I don't know.
Denim.
Okay, thank you. I appreciate that one. All right, bye. That one wasn't bad as far as my dad jokes go. Denim is the sounds that the first music that's played when you go into the dungeon when you go underground in Mario. And it's also sort of the end. I think when you die, they play that sound. That was great. Okay. I've debated telling you this. It was a major interesting weekend. Okay, so Friday night I go out and I'm live streaming this class. It's actually a parenting class, right? It's like how to parent, and what a better thing for Mrs. R.A. and I to do after having raised about 6 of them, to go and learn how we did it wrong, right? And so I show up at this class, and the room where they're doing the live streaming out of is being used by somebody else. I've got 1 hour to set up everything I need: audio, cameras, cables, wireless microphones, everything. I've got an hour to get it set up, which is enough time, and it's being used by somebody else. It takes them half an hour to finish up and get out before I can go in and start setting up. So I'm flying through, setting up PTZ cameras, running cables and wireless connections, and and the presenter comes in and he's like, I was just going to like turn my laptop on and, open Zoom and hit record button on Zoom, so it would just be filming me. I'm like, okay, you could do that. I happen to have brought about $15,000 worth of gear to make it a little bit better if you would like. And so we ended up using my gear. And now they're like, can we do the same thing for the next 8 weeks? So I'm like, yeah, I'll do it for the next 8 weeks. It's going to be great. So anyway, so we did that. Live streamed my friend's funeral service, which was awesome. And his brother actually got up and told a joke during the funeral, but it's one of those slow burn jokes that has a long setup, and I think most of the people there didn't get it, but it's a really good joke. Yeah, my friend would have would have appreciated it. But it's about the lead singer of Nickelback. So anyway, it's a funny joke. I might share it sometime. I'll wait. It's not time yet. Let's see. Is the interview from Saturday up? It is. It's on Valhalla Awaits channel. That was Saturday night. We're live streaming, doing stand up at funerals now. Apparently. And then on Sunday, I set up. I live streamed a conference on Sunday, a church conference on Sunday, and I set up for we did test runs for another conference that's coming up in 2 weeks that I'm live streaming. And that one, instead of just like taking a video camera and putting it out on Zoom or something or YouTube, we're running 2 cameras, which are pan tilt zoom cameras, one mounted in the ceiling, one on my tripod. So I have to be able to control both of them with my little joystick controller system, which I configured yesterday. We have to run it in English and in Spanish, so I have to have a team of translators with their audio and the audio levels, so that in case they're not translating, so that's like music or something in the background, that sound has to come through, but if they start translating, the sound will drop down, so I just get them. And that's going to be on 2 separate YouTube channels. Then we're going to... So we'll have to run it in English and Spanish. And then they also said, oh, and by the way, we have some deaf people. Can you incorporate closed captioning? No problem. Got it done. And so we're going to do that in 2 weeks. So that's the next big one. Anyway, fun stuff. And somebody, I don't know who it was, somebody tagged me in a discussion on, there's like a radio show out of like Alabama. The guy's trying to do he's doing a podcast, doing really well at it. And somebody said, you should do a live stream on YouTube. And somebody's like, you should see Recovery Addict set up. And I have no idea who this channel is, but I don't know who it is. But they post a picture of my setup. It's like, here's how to do YouTube. Look, you just use what's on his desk. So anyway, that being said, there's the link to the Valhalla Awaits interview. I apologize. I apologized to them after. I said, I'm sorry. I was so focused on building these Legos that I was probably your worst interview ever. I was like committed to getting these things done, but and I failed on both fronts. All right. With that said, it's Monday. We were going to do a little bit of court hopping this morning to get warmed up into watching what we're doing. Let's see who's up. Somebody just popped up. Simpsons not quite live yet. He's going to be live in a little bit. We had... What's this one? This just barely jumped up. What is this?
By the TRRC program.
Hang on.
Everland sign on behalf.
Backing up.
Defendant is present, represented by Attorney Michael Morosky. People are represented by Prosecuting Attorney Timothy.
Is this the ice fishing
Court
courthouse?
is in receipt of a request and summons for probation violation dated February 21, 2025. Ms. Karen Everland signed on behalf of Mr. Nathan Lick, probation agent, where it's alleged that the defendant committed the following technical probation violation. In that on or about February 20 this year, he was found to be in violation of Special Condition 9.10, which states he's to comply with the drug treatment program, pay all fees as required, and abide by the program rules as defined by the TRRC program committee team, including any aftercare programming. It's alleged he was discharged unsuccessfully from the program due to violations of the program. Mr. Hunt, do you understand the allegations here, sir?
Yes, Your Honor.
Now, you're entitled, obviously, to the assistance of Mr. Morosky. He's here to represent you. You are also entitled to a full probation violation hearing where it must be shown by preponderance of the evidence. In other words, more likely than not, that you violated the terms of your probation. Beside all of that, you are entitled, that is, to disclosure of all the evidence against you, an opportunity for you to speak in your own defense. You have the right to remain silent. Your silence cannot be used against you. You have the opportunity to present witnesses and the opportunity to confront and cross-examine all witnesses against you. Understand those rights, sir?
Yes, sir.
If you're found guilty or plead guilty to the alleged
So he's in violation of his bond. Let me back
the
up a little
maximum
bit.
sentence you can serve.
Allegedly.
Now, my notes indicate 5 years. Let me make sure.
5 years.
Yes, 5 years on count 1, 4 years on count 2. You understand that, sir?
Yes, sir.
Mr. Morosky, how did your client wish to proceed?
Your Honor, after speaking to Mr. Hunt, at this time he wants to plead guilty to probation violation.
Okay, so we're going to back up for a minute. Josh has one for us that he says we need to watch. That's going to be in trial today, and it's going to be it's in the Minecraft court. You guys remember Minecraft court? Judge John P. O'Donnell. This was from 4 days ago. The trial comes on today. And let's see, so start at, says part you can't hear, but the part you can hear is good. Start at 5 hours and 35 seconds. Let's jump to 5 hours and 35 seconds, shall we? Then we'll have court today in this one as well. $5:35. Here we go. Bzz, bzz, bzz. Then it went black. Wait for it for a second. It'll come back. There we go. All right. So our guy is the guy in the orange hoodie. Hopefully you get the audio turned on here in just a second. Otherwise I'll have to tune out this buzz. We are waiting for it to kick in with the audio. Let me skip forward and see when it starts. Still nothing. Says the part you can't hear is worth it. Josh, do you have the timestamp of when the audio starts working? Oh, there it is. Okay. Oops, now we back up to about where that was.
Statement. It has.
Okay, here we go. It's going to start right in the next 5 seconds. Here we go. So trial starts tomorrow, not today.
To qualify as hearsay.
Of its statement. It has to be able to be sworn in by that person making that statement under the penalty of perjury.
Everybody who sits here is under the penalty of perjury when they talk from the witness stand.
That's correct.
Right. So what comes after the jury? What type of, what was that?
That was my speakers bleeding through.
What type of, what are the categories of exclusions when you have jury selection?
Like I said, that would be something that I would have to get more familiar with, but I would imagine one of the categories would be, no, I don't know the per se categories, but if you have a juror who makes prejudgmental statements, I would assume that would be basis for exclusion of a juror.
Under what category of exclusion, do you know?
I'm going to assume bias. I can't actually say because I have not done that study as far as jury selections as of yet.
All right, so you got to figure out the procedure for jury selection and what the rules are, right?
He's the defendant?
You got to figure out.
Why is his lawyer not talking?
And study the evidence rules.
Correct.
Right? Okay, what comes after jury selection?
After jury selection, so in between a jury selection starting, and then you're saying after jury selection, are jurors already admitted at that point?
You tell me. You want to be the lawyer, you tell me.
I would imagine there's a opportunity to admit any jurors after a jury selection has been made based on whatever the credentials are or criteria for that basis, and then trial would start.
Okay, and how does the trial start?
He's teaching the judge here.
I've never been to trial, Judge, so I don't have all the answers to these questions, but it's something that I can be aware of prior to trial.
Well, that would be, the opening statements would be the next thing that comes after jury selection.
That's correct.
Who goes first?
Who's ever making the accusations would be.
And who's making the accusations?
In this case, it would, I'm assuming the state.
Okay, and then who goes after that?
It would be the accused.
What's the purpose of an opening statement?
To familiarize the jurors or the atmosphere with, I guess, the basis of their claims.
Okay. What happens after the opening statements?
I think witnesses would be called.
Okay, who calls witnesses?
So if one side doesn't have any witnesses, the only witnesses that can be called are those that are available.
That are what?
Those that are available.
And how are they made available?
Through summons.
Okay.
He's doing okay.
If you're going to represent yourself, how many witnesses are you going to call?
I think I'll be cross-examining whatever witnesses that do show up.
Right. That's it?
That's correct.
No witnesses in your defense?
What comes after all the witnesses are done?
Closing statements.
Right. And who goes first?
Who's ever presenting the claim, who actually have a claim.
And that would be who?
In this case, I'm assuming the state.
Okay. Who goes next?
It would be the accused.
Okay. Is that it then?
and then
Jury instructions.
there's deliberation.
Okay. What about jury instructions? Have you looked at those and what to submit?
That would be another one of the three that I'll be looking at prior
Okay.
to.
He's got a lot of homework.
Now, you don't think that Ms. Hibbert has done a very good job here?
I actually think that she sabotaged my opportunity to have a defense in line with my constitutional rights.
Okay, why do you think she's done that? I mean, that's a conscious act, right? You're accusing her of consciously sabotaging your case. Why would she do that?
Correct. Because I've informed Ms. Hibbert on multiple occasions, which I understand if it's out of her hands, she can't make something appear out of thin air, but I've informed her that there's body cam that would support what I was claiming. I was informed by her that there is no body cam from Willoughby Police Department. I informed her from the day that I met her that my constitutional rights were violated by them entering my home without a warrant and searching and allowing others to do the same that weren't residents. I explained that to her, and it seems to me the only thing she had enthusiasm with or about was me signing waivers. And in particular, the first waiver that was signed was that at a preliminary hearing where she says to me, it doesn't really matter if you sign the waiver or not. All the police officers have to do is take the stand, and eventually an indictment will be served based on their
What's the
based on their words.
When there's a preliminary hearing, what does the judge have to find?
So, in a preliminary
What's the standard the judge has to find has been met?
In a preliminary hearing, you have to find that there's basis of the claim that's being made.
Okay.
And I didn't get an opportunity to basically be present if the claims were being made and when claims were being made because of coercion through Mrs. Hibbert.
Okay. So the bottom line is you're facing a trial next Tuesday, and it's your belief that you're more qualified to do that job than Ms. Hibbert.
I wouldn't say the word qualification, but it depends on how you're using your qualification. Like, I say I'm more qualified to protect my liberty than she's willing to.
Okay. What happens when you ask a question on cross-examination and the state makes an objection to it, and I sustain the objection? What happens then after that?
So if you sustain that objection, it would have to have been based on some type of procedural etiquette that's accustomed to how procedures work. And then that means there's guidelines that have to be adhered to.
Okay, so the state puts a witness up here. Ms. Wood finishes questioning that witness. You get up to question that witness. You ask the first question. Ms. Wood makes an objection. I sustain it. What do you do next?
So if the question can be reiterated to that quote-unquote witness, then that's what has to be done.
Okay,
if there's a point to be made,
what do you mean reiterated?
Readdressed.
Okay.
Because obviously if you made an objection and you agreed with, you sustained her objection, you agreed that there was some guideline not being followed or
a rule being violated,
or
right?
a rule being violated.
Okay. All right. So you're better prepared to protect your liberty than she is what you're saying.
I think I'm more willing to.
So she gets paid just to sit there.
See, I don't think you have the slightest idea what you're doing in a trial. It may seem easy sitting here, but I had one guy represent himself, and by the middle of the first afternoon, he wanted his lawyer back because he had no idea. He thought he knew what he was doing. He thought he was the one that's going to be better able to represent his interests. He had no clue what he was doing, couldn't figure out what he was doing, and it was a disaster.
I'm not him, though.
Well, you're not him. Of course you're not him. I've never seen somebody represent themselves that has done anything approaching a serviceable job?
Only because people who proceed pro se don't have the habitual experience that, say, a licensed attorney or even a prosecutor have.
Attorneys do this by habit.
Doing the same regimen over and over again and have been familiar with each other.
Okay. Let me ask you this.
Keep using big words, but I don't think you know
What's
what they mean.
why are you under disability why are you prevented from having a weapon?
That's the charge.
So in 2008, my home was invaded. I protected myself, but inevitably or unfortunately, I was charged with an assault, and that's what gave me a felony.
Okay. Felonious assault in December of '08, right?
Correct.
Therefore, you couldn't own a firearm or possess a firearm, right?
That would be correct.
Okay. So what does the state have to prove on that count, having weapons under disability? What are the elements?
If I tell you any more about what the state has to prove, I'm basically helping the state defeat my
Well, they already know what they have to prove. They're the ones that brought the indictment. They know what elements they have to prove. One thing they have to prove is that you got a felonious assault conviction in '08, right? Right?
That would not be untrue. That's already listed.
I know that. So they have to prove that, right?
Correct.
So there's going to be presumably somebody here that's going to testify that you got a felony conviction for felonious assault in '08, right?
Let me ask you that, Judge. What you're saying now, would that not be the same criteria what Mrs. Hibbert did to me at the preliminary hearing by saying all the police have to do is take the stand and an indictment would be served?
I don't know what one has to do with the other.
What you're saying right now, it seems eerily familiar to what she said back then.
I wasn't there, so I don't know what she said back
waiver
then.
being signed.
All I know is that they have to prove, in order to convict you, in order for the jury to convict you, they have to prove that you didn't have the ability, you didn't have the legal ability to possess that weapon or own that weapon because you had a felonious assault conviction in '08. So they have to put on proof through witnesses that you have a felony conviction for felonious assault in '08.
So how was Ms. Hibbert being able to help me in that same scenario?
I'm not talking about whether Ms. Hibbert is going to help you or not help you. I'm saying, do you realize that there's going to be testimony that you have a felonious assault conviction in '08 as part of this trial? Did you know that?
That I understand.
Okay. So you really want to represent yourself?
Yes, I do.
Okay. All right. Do you have anything that you would like to
range of punishments?
Thank you, Your Honor. We would ask if the court would speak with the defendant about the remaining charges, the potential consequences, the range of punishments possible as well, to see if he understands that nature, as well as he mentioned his educational background, any mental health diagnosis or substance abuse issues that would prevent him from knowing and understanding what was occurring.
Well, I guess the question is, from our dialogue, does he understand those things? Do you know what the penalty is for this felony of the third degree for having weapons while under disability?
Up to 3 years, is it not?
It is. What about the possession of cocaine?
Ooh.
I was not informed of any other penalties or possible penalties.
I'm just going to state for the record that that's not true.
Well,
I did inquire, but I was not informed.
Okay,
Yes, you were
so I'm going to
informed.
inform you, but I doubt it, that what you're telling me is accurate, but the fifth degree felony possession of cocaine is a potential 12-month prison sentence. You understand that?
That I do.
Okay, so with the F3 and the F4, there's a potential of 48 months in prison. You understand that?
That I do.
Okay.
4 years. Gambling with 4 years of your life here.
Now, Ms. Wood brought up a good point. Have you ever been found to be mentally ill?
I have not.
Diagnosed as mentally ill?
I have not.
Treated for any mental illness?
I have not.
What high school did you graduate from?
I actually dropped out of high school and went back and got my GED.
When did you get that?
2000, year 2000.
Right. And where'd you go to college? You said you had some college?
Some colleges. Went to Ashland University and I also went to Lakeland Erie College.
Okay.
Judge is
All right.
spinning his pen on his desk.
Anything else that the state would like me to inquire into?
You have one moment, Your Honor. I did provide the court a waiver of counsel to see if the defendant would be willing to sign it, because he has been advised that he has an absolute right to counsel, and it is his decision to proceed pro se.
This is the week before trial, yeah. Trial starts tomorrow.
Mr. Jordan, there is a judgment entry here that I'm going to ask you to sign. It indicates that you've been, having been warned otherwise, which I advised you was a bad idea to do this, you're going to voluntarily waive your right to be represented by counsel, because you have a constitutional right to have a lawyer represent you in this case. And you don't want that, you want to represent yourself, correct?
Because of ineffective assistance of counsel.
Well, whatever the reason, it doesn't matter. You could want to represent yourself because you don't like the color of her hair. It doesn't really matter what the reason is, but you're waiving your right to have a lawyer represent you, your constitutional right, is that correct?
I'd rather represent myself.
Right, so you're waiving that right to have a lawyer represent you.
The only right I would be waiving voluntarily.
What?
It would be the only right that I had waived voluntarily.
All right, well, then I'm going to ask you to sign this entry. Can you take that over to him? And that's a waiver of your right to be represented by counsel.
No bailiffs? Check my pocket, see if I got a pen. Don't have a pen. Can I borrow yours? Yeah, I came to court. I don't even have a pen, but I'm prepared to defend myself. To his credit, he is reading it first. Make sure he's not signing away like the deed to his house or something. Wheeler, troublemaker. Wheeler's the only person who got thrown into jail for contempt of court before the trial started. He's like, Judge, I refused to sign your paper. This guy stand a chance? Probably not. I haven't seen the evidence. Obviously, it has to be proven. I don't think the state would bring these charges if it had nothing. Right? This is not a kangaroo court. This judge is a great judge. I think he's going to make them prove it. But of course, the defendant has no understanding of what would be objectionable and why.
Mr. Jordan's signature appears on the signature line, waiving his right to counsel. You filed also a motion to vacate arraignment, motion to dismiss, lack of jurisdiction, denial of due process of law. What do you want to say about that?
Oh, goody.
So, under the guidance of ineffective assistance of counsel, I attended an arraignment on December 6th, which was outside of open court in compliance with Ohio Civil Rules of Procedure and that of Federal Civil Rules of Procedure.
What do the federal rules of civil procedure have to do with this?
Which the arraignment was in the lobby.
I know, but what you said, you mentioned that it violated the federal rules of civil procedure. What does that have to do with this proceeding?
Meaning, a court procedure is to be in open court defined as in a courtroom and on the record, and being on the record, thus having a overseer or judge present, and neither of that happened.
You wanted a federal judge present?
No, but a judge would have been present as far as federal procedures.
Okay, my understanding is you waived your right to be present at the arraignment.
And that's where
with a not guilty plea to be entered, and the bond was set by agreement.
That's where the ineffective assistance of counsel has occurred, because during that unofficial or illegal proceeding, the way Mrs. Hibbert described to me the paper that I was signing with a paper over the heading of the paper that it was signed were what the state is charging or claims that they are making. So it was dated the 6th day of the arraignment. I don't know how I can waive rights at an arraignment of an arraignment. And they were misrepresented by Mrs. Hibbert. And my belief is that that happened because there was no judge present.
What was your bond?
Excuse me?
What was your bond?
In reference to the bond conditions that she...
No, the bond. What was the bond amount?
$10,000.
Okay, did you post it?
During this arraignment...
Not during the arraignment. Did you post? Were you out on bond at the time of the arraignment?
During the time this arraignment happened, I was already out on bond.
Okay, so you posted it in Willoughby Court?
I was already out on bond. I
Right.
believe it was...
When you left the lobby of the jail after the arraignment waiver, did you leave the process? Did you leave the premises, or did you get locked up in jail?
Can you repeat that again?
When you exited the lobby of the Lake County Sheriff's Office where the arraignment waiver procedure was taking place, did you go to jail, or did you just leave after the procedure?
I'm not understanding. Are you saying on
All right.
December 6th?
December 6th, did you get locked up in jail?
Let me understand. Let me reiterate if I understand. Are you saying after the arraignment of December 6th, as I left the arraignment, did I get locked up?
Right.
That did not happen.
Okay. All right. Is there a waiver of arraignment in this case, Ms. Wood?
Yes, Ms. Hibbert is looking at that waiver right now.
Can I see that? All right, so this was the waiver of the right to be at arraignment on the indictment, the same indictment we're talking about here. It is signed by Mr. Jordan. The bond was continued at 10,000 cash or surety with certain conditions. So you were arraigned. You waived your right to be present in the courtroom for an arraignment and agreed to the bond that had previously
Let
been
me
set.
be clear, Judge. That is the reason I filed for a removal of a
All right, that's done. She's removed, okay?
Right, and that is the reason why, because of her manipulating the waivers.
So this motion is to vacate the arraignment. That's denied. There's a motion to dismiss for lack of jurisdiction and denial of due process. You want to address that?
Can you explain why the arraignment is vacated when it was not held?
It's not vacated. Your motion is denied.
Denied when
Denied
it's not?
because you waived your right to be present at the arraignment.
That signature was coerced through her by her covering up the title.
Well, I've denied the motion, so let's move on to the next thing. The motion to dismiss for lack of jurisdiction, denial of due process.
So you blatantly deny my due process?
I denied it, and we're moving on to the next thing. I'm not arguing about the arraignment. I've made a ruling on it, okay? That's it. So let's move on to the next thing.
You do know that you're acting biased right now.
Do you want to move on to it, or do you want me to hear your argument? If you don't want me to hear your argument, I'll look at the paper and I'll make my ruling on the paper. You decide. You're the lawyer, so go ahead. I mean, every time you get a ruling that's adverse to you doesn't mean it's biased, okay? All right? So do you want to address the motion to dismiss, or do you not?
Read the title of the motion to dismiss for me.
No. You filed it. It's your pleading. You read it.
Tell me again what's in the motion. I just copied it off the internet. Hang on.
So yeah, motion to vacate arraignment, motion to dismiss lack of jurisdiction, which would have been during the illegal arraignment.
So is the motion to dismiss based on your belief that there's an illegal arraignment?
Not by not having a judge present allowed Mrs. Hubbard to coerce the accused into signing a waiver that she misrepresented. Like I said, she covered the title of the waiver up as I was signing it.
Okay.
And she did not, and she explained to me as what the state simply is charging me with. So, through her misrepresenting herself as one who seeks to help me, that waiver was obtained basically through an illegal procedure.
Okay.
We've already dealt with that
All
issue.
right, so it's based on the arraignment.
So-
The motion to dismiss is based on the arraignment?
As well as the denial of due process of law.
All right, so that motion's denied. All right. We have a jury trial that's set to begin on March 11.
You can't believe it got denied.
Ms. Hibbert is going to be
He's still stunned.
present as standby counsel
And she's like,
throughout
yay.
the trial.
Yay.
You can either consult with her during the trial or not consult with her. It's up to you. There is a motion filed by the state for remote testimony. Ms. Wood, you want to address that?
Thank you, Your Honor.
There you go. She handed
The
to him.
state filed a
There it is.
motion for remote testimony of the witness Destiny Thomas. The case law was cited in our motion, and the specific reasons are fact-specific to Ms. Thomas. She is currently residing in Franklin County, Ohio, which is about 2.5 hours away from Lake County, Ohio. She is temporarily residing in a domestic violence shelter. She does not have stable housing. She does not have a driver's license. She does not have a car to travel up here to Lake County, Ohio. Furthermore, she was homeless before she was placed in this shelter, and she has to abide by the shelter rules, which require her to be back in the shelter by 10 p.m. each night, or she could face and risk losing her spot in that shelter and becoming homeless again. She is worried about her items being taken should she be away from her shelter for an extended length of time to come up here, travel to Lake County, testify, and then travel back to Franklin County, Ohio. In addition to that, she is also 5 months pregnant. She informed me that she is high risk, which require additional doctor's appointments to be monitored, and she has some concerns about the physical state of her well-being, about being in the car for 2.5 hours up here and 2.5 hours back to Franklin County, Ohio. So we would ask that the court make a finding that Ms. Thomas may testify by remote means. The state would facilitate the setup of the remote testimony. Her physical demeanor would be depicted on the screen. There would be a video image of her as well as audio. She would still be sworn in and subjected to the same requirements as if a witness was here testifying on the witness stand. And she would testify to her involvement and observations prior to the police arrival involving the drugs that were charged here and the firearm that the defendant possessed, and what occurred prior to the police arrival. She is a necessary witness, and so we would ask that the court make a finding that that remote testimony be permissible. Thank you.
Response from the accused?
Mr. Jordan?
I object. Her not being present would not be considered hearsay.
How is that considered hearsay?
Close. You're thinking out of
I
court
would have
statement.
the same effect of being able to cross-examine her with her being on the screen in a silhouette, did she say?
What?
I would have the same advantage of being able to cross-examine her as the state would have to examine anyone that I had on the stand, but I understood that she said it would be a silhouette of her. Is that correct? Is that correct?
She's going to testify, and she'll be right on the screen.
Cross-examine her shape. Virginia, happy birthday.
Then no objection.
Okay. So Mr. Jordan does not object, so I'll permit that.
She'll be on Zoom.
Thank you. We will facilitate that testimony.
All right, and then there is another motion that Mr. Jordan filed this afternoon at 2:13.
They hurt. Fingers are so sore.
it's a motion to dismiss corpus delicti. You want to make a copy of that for,
I
do you have it?
I have it,
All right,
but I
never
don't
mind.
think
I
standby
don't,
counsel.
I don't have it. Thank you. Sorry. Or do you need this?
I'll keep it.
There's two.
To what?
Two motions. There's a motion to dismiss corpus delicti and a writ of estoppel.
Okay, you want to address the motion to dismiss corpus delicti, Mr. Jordan?
Yes, I filed a motion to dismiss corpus delicti, claiming, not even claiming, but pointing out that there are no injured parties to the state's claims, and there are no damaged property to the state's claims. In reference to jurisdiction, I was asking you prior, what jurisdiction were you intending to try me under? And you said, what was the case, criminal or civil? And you stated criminal. I then, like I said, sought to ask you before you left the courtroom, under what jurisdiction are you trying this criminal case? According to Article 1, Section 8, Clause 17, there are two jurisdictions, one common law and the other military or naval tribunal.
Statutory. What about a violation of the statute?
I have never heard of a statutory jurisdiction according to the Constitution. If you can so point me to where I can find the guidelines of procedure for this statutory jurisdiction.
So I don't have jurisdiction to try you, for the state to bring a charge under a violation of the statute?
So can you point me in the direction?
So is your motion that I don't have jurisdiction in this case?
Let me be clear on it, Your Honor.
Please, I'm trying to figure out, do you have that copy, Bob?
If you can point me to where I can find statutory guidelines of rules of procedure.
I'm not pointing you anywhere. You're the lawyer.
They're not listed anywhere.
You're the lawyer. You tell me the basis. You tell me the basis of why there is no jurisdiction here, according to your motion. So make your argument.
Let me ask you once.
I'm not answering questions. You're the lawyer. You present your case as to why you believe this should be dismissed. I'm not answering questions.
Let me be clear.
You're making arguments, and I'm making rulings. That's how this goes. See, this is a problem already, okay? Because you want to be a lawyer in this case, so go ahead and be a lawyer.
So, Your Honor, you've already stated that it's a criminal case proceeding against me, and I've asked you under Article 1, Section 8, Clause 17, under which jurisdiction would this criminal case proceed, whether it be common law or military tribunal. I haven't received an answer from that yet.
Do you have a response, Ms. Wood?
I don't know how to respond to this.
Okay. Anything else you want to say on your motion to dismiss?
Sure. Let me be clear. So the state is claiming injury to personal property? Is that the case?
Are you telling me?
I'm asking the state.
They're not answering. We're not here to have a question and answer session, okay? You've got a motion.
I like how he handles this.
So I'm telling you, you tell me any argument you have in support of your motion such that it should be granted.
So let me ask.
No asking questions, okay? Make argument. You're a lawyer, make arguments.
So the one who's making the accusation, I know I have, under the 6th Amendment of the Constitution, a right to know who's making the accusation and to confront that accusation for its validity.
That's what a trial is for.
And you're supposed to, as being on the bench, is to oversee that process, right?
That's right.
So
we're in a rule on things, to make rulings.
Are these charges or claims that you're bringing against me of common law jurisdiction or military tribunal?
This is not a question and answer period between you and the prosecutors. Okay?
Because let me just be clear.
This is a chance for you to make your argument to convince me that I should grant your motion.
Right, because, Judge, if it is a military tribunal, since she doesn't know how to answer it,
well, don't.
There must be. Let me finish.
Listen, no, I'm not going to let you finish.
You said
I will let you finish making your argument.
That's what I'm doing.
No, you're asking questions.
No.
Make your argument.
My argument is if this is a military tribunal that she's tried me under, my difference with that would be that there is no international contract in dispute. And if this is that of a common law
What
jurisdiction-
international contract? What are you talking about?
And if this is that of a, you're just supposed to listen. If this is that of a common law.
Now, see, you don't, there's a problem that's creeping up here that's gonna rear its ugly head first thing Wednesday morning, or Tuesday morning, I fear, okay? You're not here to argue, okay? Right now, you're here to convince me on your motion. I'm not engaging in an argument. Now, I'm talking now, okay? I'm not here to have an argument with you. You're not here to have an argument with them. You address me, they address me, I make a ruling, that's it, okay? Now, I sense, the more and more we talk, that you're kind of a disruptor. And I'm telling you, I'm telling you, on Tuesday morning, if you attempt to disrupt the procedure and talk out of turn, okay, I'm not gonna put up with it. And if you do that, then you're not gonna represent yourself. Ms. Hibbert will be back in charge, and you'll be at another location remotely watching the trial, okay? So, you want to represent yourself? You conduct yourself as a lawyer that other lawyers do when they come in here. It ain't a free-for-all. You understand that?
That's clear, Judge. I hope
All right, now get back to your motion to dismiss.
So, as I was stating, according to Article 1, Section 8, Clause 17, there are two jurisdictions that a criminal case is tried under. One being common law, the other being that of military tribunal. And no one has answered the question of either. But if there is one to be under military tribunal, like I said prior, there is no international dispute of a contract. And if it is that one of common law, I'm saying now that there is no victim who has injury to self or property making that claim present. Those are my grounds for dismissing this case. There is no person here saying that I caused them harm, injury, or to property under the common law, and neither is there a contract in dispute for the military tribunal, and neither have been addressed outside of the arraignment that no judge was present.
All right, anything else with regard to your motion?
That'll be it.
Do you have anything, Ms. Wood?
Yes, Your Honor. The state is asking for some guidance on the discovery that has been provided to Ms.
As to this
Hibbert.
motion?
Oh, as to this motion, no.
Okay, the motion is denied.
Okay.
All right, and there was another motion?
There was a motion, a writ of estoppel.
Okay, go ahead, address your writ of estoppel.
So the writ of estoppel is in reference to the coercion and unethical practices that Ms. Hibbert exhibited by or through her representation of me, or misrepresentation, in which she coerced documents to be signed by making statements that were, like I said, unethical. She made the statement, if I did or did not sign the waiver, or if I didn't sign the waiver per se, there would be an indictment either way, just by the officers taking a stand. She misrepresented it at the arraignment that was outside of open court by covering up the heading of that document as I signed that document. So that's in relation to her misrepresentation and those documents per se, which were obtained.
So what is it you're asking by the writ of estoppel?
For those documents to be omitted, since they were gained.
What documents?
Those waivers that were signed.
The waiver of the right to be present at the arraignment?
Correct.
All right, I've already dealt with that, so that's denied. All right, now go ahead, Ms. Wood, as to your issue.
My issue is for some guidance from the court on the discovery that has already been all provided to Ms. Hibbert. Will that be then transmitted all to the defendant prior to trial next week?
Is that all in electronic form?
Yes, and Your Honor, we probably would be able to put it on I would have to consult with Mr. Jordan to be sure that if we put it all on a flash drive or hard drive for him, he would be able to, he would have the means to access it and view it. But I think it would be easy enough because I save it all in folders to do that for him and get him a flash drive or hard drive. And we would certainly do that as quickly as possible, being that the trial date is next Tuesday. We could probably have it to him to get this accomplished tomorrow morning.
Okay, so then,
And supplemental discovery as well. Should I leave it at the front desk for Mr. Jordan to then come pick up at his convenience at my office?
why don't you do this, since Ms. Hibbert is still part of this case, transmit any supplemental directly to her, and also leave a copy at the front desk at your office for Mr. Jordan.
Okay.
And then Ms. Hibbert, you will then, as you described, get that, what you presently have, to Mr. Jordan, and that's part of the order.
Okay. And as to the counsel-only materials such as criminal histories, those are now permitted to be transmitted to the defendant?
Yes.
Okay. Thank you.
Okay. All right, anything else from anybody?
No, Your Honor, thank you.
All right, then everybody is to be here Tuesday morning by 7:30. Okay?
Thank you, Your Honor.
No, thank you. No, thank you from the defendant. He lost all four of his constitutional challenges were unbelievably, surprisingly thrown out. I thought he was going to walk out of here with a win. He was so well spoken. Probably some of the, I would put him for a pro se sovsit. He ranks near the top for, and I'll put him this. I'll give him credit for this. He knows his stuff. Many times you get a pro se sovsit who can print something off the internet and read the statement and not even know what the words mean or how to pronounce them. He has some vocabulary issues, but by and large, he understands the general process of court, how it works, the order, who the players are, how the trial will proceed. That's a big win. And he understands the argument of a pro se sovsit, which does not help him anything when trial starts tomorrow. So whew, that's gonna be a doozy. Josh, keep us in the mix on that one as we wait for that one to come to light tomorrow. That's from Judge John P. O'Donnell's courtroom, also known as Minecraft Court. All right, let's see. It looks like Simpson is...
Michael Mueller in court today. Could you please point to him and describe something that he's wearing?
He's in the back wearing a red scarf as well as a white shirt and white pants.
And I guess I failed to ask if people can remove their...
Let's back up a little bit. Hang on. Let's back up. What's happening today in Judge Simpson's court? Hold tight. See, we want to see the very beginning so we get everything that's going on. Okay. Bum. Okay. There we go. All right. Full courtroom. I'm going to put this on 1.25 speed just so we can catch up before it ends, because he likes to delete everything as soon as it ends. Tables are full. Is that a new prosecutor with this yellow scarf? It must be civil. Do you think it's civil? Is he overseeing a civil suit? I believe the one next to him, it looks like a prayer shawl. So it could be an article of religious clothing. Bailiff is tall. The bailiff, oh my goodness. Bailiff on the right. Looks down on everyone. Oh, we've got a kid in court, too, next to the tall bailiff. It's awesome. Everyone take your seats. Is that guard on the left, that the glass around the desk, is that new? What I would call it a sneeze guard if it were at a salad bar, but just right above my head here. Is that new? Thanks, Josh. I'm not sure. We might bail depending on the content, but we'll see what happens here. Criminal preliminary.
Court does call the cases of People State of Michigan versus Lewis versus Willow versus Hunter Fromm versus McKean Shapiro versus Miller versus Eaton and versus Haslett.
They're suing everybody? What?
That's right.
It's a huge case.
My feelings exactly. Counsel, please state your appearances.
Good morning, Your Honor. Assistant Attorney General Sean Ryan.
Good morning, Judge Ryder Ron, PA 3665, Memphis, Florida.
Lauren asking on behalf of Mr. McKean Shapiro.
If it please the court, John Minnick on behalf of Avi Talking From.
Morning, Your Honor. Mayor McAdoo representing Samantha Lewis.
Good morning, Your Honor. Stacey McNulty representing Oliver Kosler.
Good morning, Your Honor. Mark Hyder on behalf of Mr. Shapiro. And good morning, Your Honor. Jamil Cujo appearing on behalf of Mr. Wheeler.
All right. Thank you.
Whoa.
And are the people ready to proceed?
We are, Your Honor.
All right. Call your first witness.
We call Officer Cargill to stand.
Waiting for we might be in Pickles Not Politics territory. Kaylee, we're going to try to find out. Josh is digging for us. This could be one related to alleged assaults during or just after the Free Palestine protests at the university campus. Reverend Beasley, I think you're right.
All right, you may inquire.
I'm going to slow it down. Tell you.
Where are you, in what capacity?
I'm a detective.
I'm sorry?
A detective.
And how long have you been a police officer?
22 years.
Always with the University of Michigan?
Now I've been at the University of
Such as?
Leon Township in Jackson, Wilson Police Department.
I want to direct your attention back to the date of May 21st of 2024 in the early morning hours. Were you working on that day?
I was.
And were you assigned to assist in the restoration and cleanup operation of the University of Michigan DIAG?
Yes, I was.
And what was your role or your assignment that day?
I believe I was squad 2.
What does that mean? What do you mean by that?
We were all separated into different squads. I was squad 2 under the leadership of Sergeant Clarkson.
And what was squad 2's role at that time on that morning?
We were going to be forming a line.
A line in regards to what? To do what?
To basically assist people for 2 back from the dive.
And what was the purpose of you being there that morning?
To remove people from the dive.
How were you dressed?
Pretty much exactly how I am now. I had a helmet on and gloves.
Okay, when you say how you are now, just for the record, can you describe just in a little bit more language detail what you have on?
It is our Class B uniform. So I have an outer interior vest, which contains my body camera, my taser, as well as my magazines, my pistol, and a BB assault fancy.
And do you have any markings on your Class B uniform?
Yes, I have my name, Cargill, badge, and please sign that.
It says please sign that.
Yes.
And in the early morning hours, where did you begin sort of organizing, if you will, that morning?
When we arrived at the location, we went to the right in front of Hatcher Library, graduate library. There's a overhead kind of a place that It's underneath the building, I'm sorry.
And approximately what time of day was it?
It was probably 5:30, 5:40.
And where did you go from there?
We moved in front, into the dining, and placed ourselves pretty much right in front of the hatch steps.
And did you hear anything going on audio-wise while you were either under the graduate library overhang or as you were entering the area at the bottom of the stairs of the Patrick Graduate
So he's
Library?
responding to a protest.
It was Director Marshall that was bringing warnings to the others.
And its purpose is to remove people from an area.
Warnings in what regard?
To vacate the premises.
Telling them to vacate the premises.
And during that time period, did you make any observations of anyone doing anything?
Yes, many of the subjects that were in the academy began to place things in front of us, such as logs, cement blocks, lights, chairs, tables.
And did there come a point in time when you moved?
Yes, it was that we started to move forward. We began to move forward and move some of those items out of the way to clear our path.
And then what happened?
We would stop until we were told to move forward. Then we moved forward to the subjects.
Okay, and when you say you were told to stop and then you were told to move, was there a particular way that you were moving?
Yes, it was pretty much a shuffle step. Just basically one step forward. We had a baton in our hand and we'd say move back, move back.
And you're also doing something with your arms,
yes.
As you were just testifying. For the record, can you describe verbally what you were doing?
Basically, we have the baton close to us and then we push it out arm's length just to move this arms back.
And was everyone that was in that line, were you in the front line, would you say?
Yes.
Okay. And everyone in that front line next to you, were they moving in the same manner?
Yes.
And there's a reason you're all moving in the same manner?
To basically protect ourselves so that nobody can get behind us and we're all in one line to secure.
Is there any kind of particular training or theory of what you were doing that morning?
Yeah.
How you were doing it? I'm sorry.
Yes, it's considered an academy training.
You mentioned that your uniform has a body-worn camera on it. Just for the record, verbally, can you describe where it's located on your uniform?
Sure, it's on my left breast, attached to a magnet clip.
And then you also have something next to that, closer to the middle of your body. Can you tell me what that is?
This is my radio mic that allows me to reach out to our dispatchers.
We're going to get body cam
Did
video.
you have your body-worn camera on and operating on May 21st?
I did.
And that was located on your body, as you described it today. Did you review your body-worn camera video before you came to court today?
I did.
Did it appear to be working normally?
Yes.
Also, as part of your assistance in this investigation, after May 21st, did you have an opportunity to review any other officer's body cam video?
Yes, I did.
And if I may, I'm ready to show some video on the screen, if that's possible.
I realize this case has a lot of politics in it, but I'm interested in the criminal side, not the political side.
Is your screen on there?
It's so far it's matching up to that.
Okay, but there's a screen in front of you that's on.
Protesting has long been a tradition in the country and a protected right. But doing it in a manner that doesn't violate the law is always important. So this case addresses that juxtaposition where protests and the law cross. So I'm curious as to where this stands. Not going to discuss the underlying reason for the protest. That's not going to help anybody here in this format.
So Cardinal, do you recognize this body cam video?
Yes, I do.
And who is it?
That is my body cam.
And you said this is about 5:30, 5:40 in the morning. Can you describe, is this where you testified that you started sort of under an overhang of the graduate library?
Yes.
See if we can get closed captioning to work here. 5:30 in the morning, the police show up to respond to a protest.
Were you proceeding to go somewhere?
I believe that is where we were proceeding to go in front of the steps I have to under.
They're looking to move protesters out of an area. Oh, you can protest. It's just you're the only one who hears it when you protest a timeout. You have no rights here, Ivan. You have no rights. This is not a democracy.
Yeah. I'll see.
They're camping. I like camping.
And at this point in time, you testified that you and other squad members lined up. Is this what we're seeing at approximately 8.2.3 minutes in your video?
Yeah, I believe we're in line formation at that point.
Okay. And where are you in relationship to the diet in which, where are you facing things of that nature?
So I'm on the eastern, excuse me, the east side of the line, and we are facing north.
I will say our nation has a history
So at this point, is everyone
protests
in the line standing?
and
Yes.
some of major developments and
Just
what
going
I would say
forward.
good things that we have done as a nation have begun and happened because of protest. We're not here to talk about the politics of specific protests. This court case, you've got individuals who were protesting, and their protest then crossed a point where legally they were told to do something else to stop doing what they're doing because of the violation or they had to move and they wouldn't, and that's where the here comes the line.
Too many people started running towards the scene.
They're saying move back.
You get a group of about 8 coming in from the northwest.
This is not a trial. This is a preliminary.
Testified that you were ordered to proceed, and is that how you can hear people say move back?
Correct, yes.
Okay. Now, I pause this. I pause this at play point approximately 4.24 minutes and 24 seconds in. This is your body cam video facing north, correct?
Correct.
And obviously your eyes are facing north and you're looking around, I assume.
Yes.
Do you recognize anyone? Did you recognize anyone at this point in time on May 21st and also in your body worn camera video?
There were a couple that I recognized prior to that, but most of it was, yes, I in this video shot.
Okay, and who do you recognize specifically and how?
Objection. Your Honor, I think there is case law specific to an officer using a video to identify a defendant in a criminal proceeding. There are 2 instances where that's permitted, and I'm citing U.S. v. Lapierre. I can get you the site shortly, but there's 2 instances where that's permitted. One, when the person to be identified's appearance is significantly changed, or 2, when the officer has a long existing relationship with that person that they are identifying. Neither of that has been made on the record, so that's the basis for my.
Well, I think that I note the objection, but I think your question, you asked a 2-part question. So I think it has to go to that. That may answer part of what defense counsel is doing.
I'll rephrase, Your Honor. Had you had prior contact with any of the individuals that you saw on May 21st up until this point in time?
Yes, sir.
Okay. And those individuals that you had prior contact with, were they personal contact as far as being close to them or dealing with them in some fashion?
Yes. We had numerous protests on campus during that year, and many people identified were participants in these prior protests.
And some had been arrested as well.
Correct.
So did you know some of their names?
Yes, sir.
Did you know what they looked like?
Yes, sir.
And based upon that prior contact and knowledge, were you able to then, on May 21st, yourself personally observing them that day, able to recognize and identify any of them?
Yes.
Okay. And now for purposes of identification with this video, your body worn camera that depicts what you're in part seeing that day, can you tell us who it was that you identified? Were able to identify?
Yes.
Hang on before you do. With that foundation, your objection's overruled. I think she's satisfied the requirements. Go ahead, Counsel.
Go ahead.
Yes, starting from the far left, there's a pink shirt, blue jeans, and long hair.
And I'm going to go to where you described with my pointer. Are you referring to this pink shirt?
Correct. That is Ms. Willow.
And you had prior contact with her before May 21st?
Yes.
Ms. Willow, do you see her in court today? And I would ask at this point in time, Your Honor, that if you would ask anyone in the courtroom who has a mask on to briefly pull them down or remove them.
Yes, those that are wearing masks, please. No, you're good back there. You're good.
Gallery's okay.
All right, go ahead.
Did you say yes or no?
Yes.
Okay. Could you point to and describe something that Ms. Willow is wearing today?
Wearing a black sport coat as well as a pink.
Your Honor, may the record reflect that this witness has identified defendant Willow in this matter?
Without objection, record shall so reflect.
She's on the far
Anyone else?
Far end of the
Yes,
table.
we're next to Ms. Willow is Mr. Fromm. Black shirt with a yellow circle with tree insignia and blue jeans.
Directly to which side of Ms. Willow?
It's her left, our right. Right there.
Where my arrow is?
Yep.
And you said that is who, I'm sorry?
Mr. Fromm.
And do you see Mr. Fromm in the courtroom today?
I do.
Could you please point to him and describe something that he's wearing?
He's wearing a tan scarf as well as a black shirt, long hair.
Could you point to him? I'm sorry, I missed it. That's okay. May the record reflect this witness is identified defendant Ayden Pickles.
Without objection, record shall so reflect.
Anyone else?
Yes, directly next to Mr. Fromm with a white tank top, black shorts, and a red hoodie as well. Could be his left arm.
Are you referring to this individual with my
Yes.
pointer is? And who is that?
That is Miss Samantha Lewis.
And do you see her in
She
court
has green
today?
hair.
Yes, I do.
Could you please point to her and describe something that she's wearing?
She is in the back row there. She has a mask covered down, white kupia and black and green hair.
Green hair.
Anyone else?
Thank you very much.
Yes.
Did you wish the record to reflect
I'm
that?
sorry.
No, it's
May
okay.
the record reflect that the witness is identified defendant Samantha Lewis. Thank you.
Without objection, record shall so reflect.
Yes, one other person just to the right, wearing red hoodie over his head. A dark colored shirt, dark colored pants.
And who did you recognize him to be?
Mr. Cosmo.
And are you referring to this individual right here?
Yes.
Where my pointer is?
Yes, sir.
And do you see Oliver Cosler in court today? Could you please point to him and describe something that he's wearing?
Gentleman wearing a white shirt and
Your Honor, may the record reflect that this witness is identified defendant Oliver Cosler.
Without objection, record shall so reflect.
Who else do you see in the picture? This is a preliminary hearing. This is not a full trial. Otherwise, we would have started with opening statements and everything else. Oh, there's a bicycle upside down bike. That I guess is now part of a barricade. The chairs are probably not going to hold it.
The G levels are 104.
Do not throw those, but then he proceeds to throw them himself.
Up until this point in time, what were you and your line doing?
We were just in formation at that point.
And now at this point in time, what's occurring?
Members of the line are starting to clear a path because the subjects are starting to throw things towards our area.
And in particular, did you notice one of the individuals that you identified previously engaged in any event?
Yes, just prior to this, Mr. Kozler takes a table and places it in front of us.
This is a political protest. We're focusing on the crime, not the protest.
Is that Mr. Kozler?
Yes, it is.
At this point in time, were individuals beginning to do other things?
Yes, they were starting to throw items at us, obviously, and it was around this time that they started to link arms.
Why are we getting that?
Do you recognize anyone in this particular play point of 547?
Yes, the subject in the brown shirt with the white mask. It's Mr. Shapiro.
And you see Mr. Shapiro in court today?
I do.
Would you please point to him and describe something that he's wearing?
He's a black shirt, no white kufiya, or black sweater, I'm sorry.
Your Honor, may the record reflect that this witness is identified defendant Henry Shapiro.
That objection record shall so reflect.
I really like those tables, those white tables. They're made by a company called Lifetime Products, and they're just amazing. They fold up flat and you can carry them sort of like a suitcase.
Officer Cargill, do you recognize, you testified just a little while ago that you started linking arms. I apologize, I don't know why.
What does it say? 30 slang words? I have to look at this.
Do you recognize, or can you describe verbally for the record what you saw that day and what is also depicted in your body camera at this point in time?
So there's numerous people linking arms. Mr. Shapiro, Mr. Lewis, Mr. Bond, are all linking arms along with other people around that line directly right in front of our line.
And you already identified this individual as Mr. Shapiro, correct?
Correct.
And then to his right, do you recognize that person?
Yeah, Ms. Lewis.
And to her right, do you recognize this person?
Mr. Fromm.
And just behind him, the head's popping out, do you recognize that person?
It appears to be Mr. Fromm.
How great are these protectors of the people?
Definitely quite hectic there. Well, that escalated quickly. Is it like a flashback or what?
As you're approaching, I'm assuming you're approaching based on your video. I don't want to put words in your mouth. What are you doing at this point in time?
So at this point in time, we are instructing the subjects to move back, move back.
Who is that that's directly in front of you at this point in time?
Mr. Shapiro.
And what, if anything, are you doing, and what, if anything, is he doing?
I am pushing forward, instructing him to move back, and he is using his body weight to push on.
Who's directly in front of you at this point in time?
Ms. Lewis.
It's the green.
And what are you doing, and what, if anything, is she doing?
I'm instructing her to move back, and she is using her body weight to push up against mine.
Objection as to what Ms. Lewis is doing here. She can only testify as to what he's doing.
He can testify as to his perception, however, what she's doing, and he was there, so objection's overruled. Go ahead.
Did you feel it?
Yes.
Okay.
Ooh, officer down, officer down.
What just happened right there?
I fell.
I tripped over a chair.
I'm gonna just pause it to adjust some audio quality.
Thank you. Is he wearing a Batman shirt?
Who is in front of you at this point in time?
Mr. Fromm.
Let me go back. Oops. You say Mr. Fromm, who is it? Where is he?
He is directly to my, he's wearing, appears to be a white mask.
Here.
I believe so, yes. Yes.
That is directly in front of you.
That's Mr. Fromm.
Let me stop. I'm just gonna stop so the record's not over each other. Go ahead. What are you doing at that point in time, and what is he doing, if anything?
I'm pushing, basically trying to use all my body weight to hold them back in there, pushing up.
And can you feel that pushback?
Yes.
You keep testifying that you were instructing or ordering these individuals to move back. When you are ordering them to do that, are they complying and doing what you're telling them to do?
No, they're not.
At this play point that appears black, what's occurring?
It is most likely because my body cam is.
I'm going to object this speculation. And also, the video speaks for itself. So if he's going to testify about his observations from that day, that's one thing. But for him to give his commentary on what's taking place in the video, I think the court can view the video and under the best evidence rule, it speaks for itself without commentary from the witness.
I don't know if it's the best evidence rule, but if he's speculating as to what's occurring at that point, I won't allow that. I'll sustain the objection. So ask you to rephrase your question.
You just testified that Mr. Shapiro was pushing against your body, pushing back. You were pushing forward, he was pushing back. Obviously, your eyes are above your body cam, correct? Is it fair to say that body camera doesn't capture everything that's going on? You can see different things versus what your body cam can.
Correct.
So when this went black, what are you seeing? What's going on?
Mr. Fromm is directly in front of me, right on me. It's essentially his chest or his body against my chest.
For the record, I want to be clear because Ms. Ryan asked about Mr. McKean Shapiro. Is this about just Mr. Fromm or is this about Mr. McKean Shapiro as well?
I apologize. I think I just spoke.
Okay,
thank you.
Thank you.
Can you talk? Who was it at this point?
Mr. Fromm.
I'm talking about.
Correct.
Who are you observing at this time?
Mr. Cosmo.
Could we please clarify, is he observing at the time or is he observing the video and commenting?
Fair.
Fair. On May 21st, who are you observing at the time of
this?
On May 21st of 2024, who are you observing that is depicted in approximately play point just after 9 minutes and 8 seconds in? Do you recognize any individual in your body cam video that you saw on May 21st?
That I knew was him at that time?
Or later learned their name?
Correct. Yes, that was Mr. Cosmo.
And can you tell me from your memory from May 21st, what are you doing in relationship to Mr. Cosmo, who's in front of you in regard, what if anything?
I am pushing forward and he is using his body weight to push back against my microphone.
And can you feel that?
Yes.
And were you ordering him to do anything at the time too?
I believe there was orders to move back.
And did he?
No, he did not.
Who are the individuals that you saw on May 21st, 2024, that are depicted in play point approximately 9:40 with the body worn camera?
Mr. Fromm and Ms. Lewis.
And what, if anything, do you remember from that day that you were doing, and what, if anything, were they doing?
I was attempting to push them back, and they were pushing against me using their body.
Could you feel each of them do that?
Yes, I could.
So I want to talk about this in a minute. We're not talking about the protest. Turn it up. We're not here to discuss whether or not Israel, Palestine, everything else. That's not what we're here to talk about. And we'll, if you want to bring that up in chat, we'll just delete you for the day. You can talk about it amongst yourselves on some of the channel. We're here for the situation where at a protest, protesters received a lawful command and failed to comply, and that's why they're here. This is not a court case trying to either support one side or the other of a protest. Protests happen all the time. I've been part of protests. I've been a part of demonstrations. And I think it's an important right that you have, but that right is not unlimited. It's not unfettered, and that's and when you try to push beyond what the rights are, then you might be civil disobedience. You have to pay the price, the consequence for breaking the law.
Did you have an opportunity to review Officer Wancha's?
Yes, I did.
And from the perspective of reviewing Officer Wancha's body cam video, were you able to recognize anyone in his video that you had previous contact with prior to May 21st?
Yes, I was.
And in that previous contact with this individual, did you know their name and did you know what they looked like?
Yes, I did.
I'm going to object to him testifying to anything in anyone else's body camera. We don't know what angle this is, where Mr. Wancha was in the direction of Mr. Cargill, and if Mr. Wancha can testify as to his own video.
Does that go to the weight or the admissibility?
Both the admissibility or the weight, but also, again, this is just someone's body camera. I don't know where this is, what point of this is. So I believe Mr. Wancha is going to testify today. He can testify as the contents of his own body camera, but I don't think Detective Cargill should be testifying to someone else's. Plus, I don't even know where this is. This isn't even where we just left off.
Judge, my objection is, I guess with his own body cam, it's kind of blended where he's testifying personal observation and then what he also sees being played in court. But with regards to another officer's body cam, he lacks personal knowledge of what was taking place. His only knowledge of that is from watching that body cam outside of court and then presumably now wanting to watch it while the Attorney General plays it.
If I could briefly respond, I might.
Go ahead.
I think all this is a little premature. I'm not going to be asking this witness to testify about what another officer did. All I'm going to be doing is showing this individual that he knows from a previous incident, showing him on this camera to identify him. That's it.
Focus on the pickles, please.
It's solely for the purposes of identification,
correct.
Not the otherwise the details of the content of what's contained in it.
Correct.
Go ahead.
Your Honor, I don't understand why Detective Cargill can't just testify to who he saw and what he saw that they thought using someone else's body camera. That's his own personal knowledge, but that's just to add.
I'm going to overrule your objection based upon the response. Your objection, which was basically, I'm going to overrule that objection also on that. Yes, I have.
I would just renew my USB lip ear objection. The sole purpose of this video is for this detective to point at it and identify a person from this video.
Yes, but the foundation which was the basis for your objection previously, he just laid regarding that prior to any identification.
I would agree on the first video, just not necessarily this one, so I wanted to make that.
What? No, he just testified to that. So objection's overruled. Go ahead.
And did you personally see this person there on May 21st as well?
Yes.
Go ahead.
Anyone from previous contact in this particular body worn camera?
Objection. He's already identified people, and this actually overlaps in time with the video of his own body cam footage.
He hasn't identified this person, Your Honor. I wouldn't be repetitive and wasting the court's time otherwise.
The problem is, I don't know who it is. So go ahead. You guys.
She's clearly asking him to make an identification only from this video. She asked him.
No, she's not, because he stated. Okay, so
you'd have to recognize him from something else.
Madam Attorney General, correct me if I'm wrong. He said he's had previous contact with this individual. He's come into contact with the individual. He knows their name.
And he also testified he saw him personally there on May 21st.
Correct.
I'm taking a point in time to demonstrate to the court what this person looks like and have him identify him for the record for purposes of identification for the exam. Unless counsel wants to stipulate to, Mr. Mueller wants to, attorney wants to stipulate.
Yeah, let's not hold our breath on that. As to your objection, I'm going to overrule it because I think the foundation has been laid for him identifying this individual, particularly if we saw them there, knew who they were, knew their name, identify it from the video.
Judge, I guess I'm saying if he's identifying him from on May 21st, says, oh, that's Mr. Mueller right there. I recognize him. Then this video is totally irrelevant. We're not making an identification based off video, but she's playing the video and he's making the identification when he watches the video later, says, oh, that's Mr. Mueller I see on the video. That's my objection. If he had seen him on May 21st and recognized him, then there's no objection there. He can make an identification off personal observation.
I don't even understand that. He's looking at the video, saying this individual's there, what he observed, and he's identifying that person from this video.
Right. And that's
or he's identifying the person on the video based upon what he had observed. So I guess I'm unclear as to your objection.
I guess I'll let her ask the question. I'll withdraw my objection at this point. That's premature.
Thank you, because it's going to be overruled. Mr. Minnick.
Can we identify the timestamp?
I'm gonna pause things right here. Kaylee says, I want to be able to talk about the legalities of protest, free speech in balance with following laws and statutes and lawful orders. The topic of protest doesn't matter at all to the combo. The topic of protest literally has zero to do with why I want to watch this. I don't want to talk about the topic of the protest. But it is this is a case that's interesting for a couple of reasons. You've got multiple people charged with an offense, a lot like YSL, but on a toned down level and with a great judge. That's interesting to me. The protests, I'm a big fan of protests. and they can be done in proper ways, and they can be very effective. There are many laws that needed to be changed in the United States, and were going back, even generations, that were changed after protest occurred, and that's okay. And if you protest in a way that breaks the law, like civil disobedience type thing, you have to be prepared to pay the consequence for that, and say, I'm willing to sit in jail for breaking this for being disobedient, because it's raising the issue. This particular protest was on public property at a university. After the fire marshal said, hey, we have a problem. You guys are overloading the circuits. We're having electrical issues. You're having open flames that are not safe. We need to change your protest a little bit, okay, so we can comply and have it be safe. And they wouldn't do that. And because of that, they're saying you need to clear out. This is not anti or pro, whatever the causes they're protesting. But once they were given that lawful order to change, first of all, to change their protest, and they wouldn't, and then said, okay, you need to clear out because it's not safe for the public. We have to preserve safety. That's when this happened. But if we can't watch it just for the legal side, we'll go somewhere else, because you guys are putting my mods to work. So. Ivan, the problem with predetermined protest areas is that oftentimes they are out of the way, they're out of the public eye, they're distant, and protests generally work better when they get more attention. And so being somewhere where you're not supposed to be, interrupting somebody's path, that's why we see protests out on major roads and things like that. We're like, we're going to block the freeway. That's breaking the law. I think, yeah, you can do that. You can all go to jail too. I'm not a big fan of that type of protest, but at the same time, you can see why somebody would want to do that. Anyway, we're going to bail on this one. I'm calling you guys out. Not responsible enough to watch a politically charged thing without making it political. Sorry, guys. We're out. You can watch it on his channel yourselves, and but I'm not going to put my mods through what you guys are putting it through. Let's see. We'll do a. Trying to see. We might go back and rewatch the house fire. The house fire has terrible audio, right? Is that the one that needs a ton of work? I'm not sure how much I can fix on that one. Let's pop in Judge Burns.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition.
That's me.
And do you understand that for a misdemeanor charge, you only have 12 months from today to file that petition?
That's me.
Judge, if this case were to proceed to trial, the evidence would show that on June 19th of 2024, officers was driving a marked unit into work, observed the defendant not walking in their crosswalk, but instead in the intersection in front of the precinct. Officers told him to get out of the street, and the defendant pulled down his pants and underwear, revealing his buttocks and private areas. Officers got out of their car to detain the defendant, but the defendant swung his fist at the officer. The officer ducked and had to use his taser to obtain compliance of the defendant.
Tase his butt, literally.
And all of that occurred in Fulton County, Georgia, Judge.
All right. Thank you.
You mooned him. You mooned him and got tased.
Good morning, Miss Jackson.
Sorry, Miss Jackson.
She's not in court. She's on the screen. I'm not talking to an imaginary person. Miss Jackson, are you able to hear us?
Everyone's doing the
Good morning, Your Honor. I was having problems unmuting and turning on the camera.
No problem. Thank you for joining us. Could you share criminal history information on Mr. Cargbo, please?
Yes, sir. He has 50 cycles.
50.
The last arrest was June the 29th, 2023, with the Marta Police Department for possession of cocaine and possession and use of drug-related objects. Those charges were dismissed on September the 7th, 2023. He does have a prior felony conviction and a sentence. This one in 2023 for felony obstruction of an officer. He received first offender treatment in 2016 for felony obstruction of an officer. That case was sealed October the 18th, 2022. He does have misdemeanor convictions. This one in 2019 for giving false information to an officer, and one in 2018 for simple battery. And there was one in 2014 out of New York for disorderly conduct. So additional one in 2014 for theft by shoplifting. And there was another one in 2014 for possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Ms. Jackson, did you say that those, at least one of those misdemeanors from 2014 was from New York?
Yes, sir.
Got it. Thank you. Ms. Rios.
Yes. Mr. Carbo, 34 years old. He's from Georgia, lived here majority of his life. He does not have any children. He has been stable on his medication since he's been in the jail. I did initially try to do behavioral health court, but he has a warrant out of Jonesboro, so he cannot go there. So what me and Ms. Ross came up with was that when he is released from Jonesboro, go get services for Pat. I have the address written down for him to go there. And for when he gets released, he'll have to go to misdemeanor probation, show up in person because he doesn't have any address or contact information. I'm also asking for his probation fees to be waived based on him not being able to, I'm not sure if he'll be able to work or have an income in the near future. And I think he's doing much better now, since I know initially had some concerns. He's found that he's fine and he's been on his medication, and talking to him recently, he's been very much so coherent, understanding everything I'm saying, and we've been able to have meaningful discussions.
So thank you for all that. BHTC said yes, but because of the hold from Jonesboro, or does it depend what the hold was? Because we have gotten people into one of the accountability courts conditionally, and then they had to go deal with a hold elsewhere. And we put a hold on them once they're gone that says bring back. And when you come back, you start your participation in whichever one of the courts it is.
Well, they said that before they could even go forward to further screening, that hold needs to be figured out. That's what the email from.
I believe you. That's not a consistent answer, because we have had scenarios where, all right, he's got to go to Cobb to deal with what's going on. It's not a murder hold, but it's a hold for another thing, a shoplifting or a.
Yeah, I had a case just like that, and they went and I think they're still there in Gwinnett County, so I'm not sure.
Okay, I'll chat with, not about Mr. Cardbo in particular, but just see why we don't have a consistent approach to that, because given the number of cycles Mr. Cardbo has, and for what, it sure seems like BHTC would be great. This sentence will get an evaluation-ish, but I've not ever seen those turn into a particularly robust treatment program, but we work with what we have. And he's got to go to Jonesboro anyway.
Yeah.
So, okay. Thank you for sharing that. Mr. Cardbo, any questions about anything we talked about?
No, sir.
Okay. What do you have down in Jonesboro? Do you know what they want you for?
No.
Okay. Ms. Jackson mentioned some trouble you had up in New York. Did you used to live in New York? What were you doing up there?
Yeah, I got family out there.
Okay. Were you visiting family, or did you live there for a while?
I was out there just visiting.
Okay. Home is Georgia for you?
Yeah.
When you get out, do you have a place to stay, or will Pad be helping you with that?
I love this
I got a place to stay.
Is that with family or with a friend?
With a friend.
Okay. Is it in the Atlanta area?
Yes, sir.
Okay. You understand that the sentence that I'm going to impose today is probation for the most part, but you won't get out right away because you have to go down to Jonesboro to deal with whatever that is.
Okay.
I mean, you'll get transferred down there. You're not going to get stuck in Fulton, but you won't be released from jail and told when you're ready, go on down to Jonesboro. You'll be transported down there to deal with whatever those charges are.
Okay.
Okay. All right. Well, Mr. Cardbo, I find there's a factual basis for your plea. In June of last year, you got upset at some officers, did some things you shouldn't. Sounds like you got tased. That can't have been fun. I also find that your plea is voluntary. That means no one's forcing you to do that. And you understood that because at first you said yes, and you meant, no one's forced me. You agree no one's forcing you to enter this plea?
Yes, sir.
Okay. And a knowing plea just means you've understood what we've talked about. Do you feel like you've understood a conversation?
Yes, sir.
Okay. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, sir.
Ms. Dilligard?
Yes, Judge.
All right, Mr. Cardbo, is it okay if someone electronically signs your name to the indictment indicating your misdemeanor plea?
Yes, sir.
All right, we'll do that. I am going to sentence you on count 1, which has been reduced to a misdemeanor, to 8 months to serve. And on count 2, which is another obstruction of officers, also to 8 months to serve. Those two will run concurrently with each other, meaning at the same time. And then finally, count 3 will be 12 months probation, and that's going to run consecutive to count 1. So you're going to be on probation for 12 months. That was for Moon and the officers. You're going to have 2 conditions of your probation. Well, there's always one, which is don't get arrested for anything. But the 2 special conditions are, number 1, you're going to meet with a doctor or a counselor and have a mental health evaluation to see if there's any treatment. Keeping up with the medication is one, but whether seeing a counselor or someone would help. That'll be the first condition. And the second is that you're going to need to do 40 hours of community service. I will waive your probation supervision fees. Have you been working recently, or is getting a job kind of tricky for you?
It's tricky.
Okay. What's the last job you had?
I was a teenager at DYS.
Oh, so way back when.
Yeah.
Okay, got it. So we'll waive the probation supervision fees. Like I said, you're not going to go to probation right away because you got to go down to Jonesboro to figure out what's going on there. Okay?
Okay.
Ms. Rios, anything else on behalf of Mr. Cardbo?
No, Your Honor. Thank you.
Ms. Dilligard?
Nothing further, Judge.
Any questions, Mr. Cardbo?
Also.
All right, you ought to be on your way to Jonesboro this week. If not, reach out to Ms. Rios and we'll figure out what the deal is.
Okay, thank you.
All right.
Yeah, you can't moon the cops. They don't find that funny. So, Judge issued a gag order in the Karen Reed
You can
case.
bring Mr. Hutchins to the door. It's not mandatory. And then are we ready on Rainey?
Yes, sir.
Gesundheit. Same County's YSL. Yes, we've had some YSL gang related cases in this courtroom that we watched.
Hey, Mr. Hutchins.
Mr. Pritchett was one of those.
I'm Judge McBurney, and your case was mistakenly assigned to me. Mr. Garland was a very vocal advocate on your behalf on Friday, and reached out to my staff to say, hey, we got to see a judge on Monday to talk about Mr. Hutchins's case. He didn't do anything wrong other than he was sort of barking up the wrong tree, and someone put your case on my calendar. I believe any bond issues, and that's what Mr. Garland wanted to talk about, was bond, need to be heard by Judge Glanville. It's a colleague of mine. I've shared that with Mr. Garland, so he knows to whom he needs to reach out to try to line something up. I just wanted you to know why you got brought over today, what you've been doing back there. Mr. Garland was working hard to get you that bond hearing, just isn't with me. That case has been assigned, your case has been assigned to Judge Glanville, I believe, for anything to do with bond. It's not indicted yet. I don't know if it will be indicted, but while it's in this pre-indictment status, I think it will be with Judge Glanville for anything to do with bond. All right?
Judge Glanville, there's a name we've heard before.
Mr. Garland will figure that out, and he'll be in touch with you. But he worked very hard to get you over here today, a little too hard, and convince someone to put you on my calendar. My calendar is for folks who had you had a first appearance on Thursday in front of Judge Brooks. And she deferred hearing bond. She's not allowed to hear. She's a magistrate judge, and she cannot hear bond on charges like yours. That has to go to a superior court judge. And Mr. Garland tried to get you in here, but he was a little too fast. So he will be in touch with you. I have sent him an email explaining what's going on, and that he need not come all the way down here today, because I won't be hearing your case for bond. So he'll work with that other judge.
I love Judge McBurney's voice cracks. Here. I wish you would back away from the microphone. It's got a great voice.
All right, ready on Rainey?
Yes.
Okay.
Why is Twitter down right now? Does anybody know?
Did you have stuff you need? Did you give your stuff to Deputy Gordon?
Did Elon not
He's got
pay
it.
his internet
Get it
bill?
to me.
Judge, that want to get a warrant signed for a briefing swap for Thomas Hutchins arguing in this court on the basis.
You just looked at him. He was that guy right there. That's Thomas Hutchins. Okay, we'll do that in a sec.
Yes, sir. Thank you.
Don't take Hutchins down. Okay, Rainey, please. Ms. Wood, are you here this afternoon, or you're just here this morning? This afternoon is different lawyers from your office?
Yes.
Okay, then we'll take care of, I have a noon Zoom, but I think we can get
This will
through.
be quick.
Oh, Rainey will be quick. Hamilton,
Oh,
I don't know, she's apparently in the building. She needs to come on up. I just don't know how quick that'll be. But we'll work through
so I
it.
can stay.
Okay.
Does he need to sit or is he standing?
Mr. Rainey, is it better for you to be sitting? Well, we're not going to talk very long, but I want you to be safe and comfortable. Is it better to sit, or are you okay standing? Okay, why don't you work your way to the podium, please?
Josh is making a suggestion for another one.
All right. Let's go on the record. This is 23 SC 188930, State versus Reuben Rainey. Mr. Rainey is here in court with his lawyer, Ms. Wood. Mr. Rainey, in July of last year, I signed a probation warrant that alleges that you became hard to find, basically. Those are my words. But we had an address for you. You weren't there. The probation officer left a letter saying you got to come on in. You didn't come on in. And so somehow, whether it was you moved or your roommates weren't getting you the mail, you were hard to find, and you need to be easy to find for probation. I'm going to let you talk to me in just a sec. I'm just letting you know the issue. So it's not the most serious thing. Sometimes with probation, it's another burglary. Oh, you can't do that while you're on. You can't do that ever, but you can't do it while you're on probation. This is one where you became hard to find, and we need to fix that and make sure if your probation officer needs to talk to you, it's a phone or you're at the address, you need to not be scarce for probation. That's the allegation. Ms. Wood, is Mr. Rainey admitting that in June of this year, he wasn't so easy for probation to find?
Yes, Judge, we're admitting to the technical violation.
All right, and that's what it is, a technical violation.
It's a catch me if you can
situation. That we do?
I'm asking for the court to revoke 60 days and reinstate. Judge has been at 57 days. He thinks that it's the correct address in their system. Is this the one you were telling me, 453 Wilson Mill Road?
Yes, ma'am.
Okay. I'm not exactly sure what the miscommunication was last summer. He was telling me that when he was released, he was working various jobs. So I'm not sure if perhaps his schedule just
wasn't lining up properly with probation. And then at some point between then and now, he was actually hit by a car.
Ouch.
He's actually in a wheelchair in his booking photo, and now he is with the walker. So he's been battling through that. But he understands that he has got to keep in touch with probation. So we're just asking for 60 days revoked and reinstated.
Maybe
Okay.
probation should
Ms.
get a
Simpson,
card.
how much time is left on Mr. Rainey's case?
He has 5 years, 7 months, and 10 days.
All right, so you got some time left on that sentence. Ms. Dilligard, your view on what ought to happen in Mr. Rainey's case?
Judge, the state, after speaking with probation, agreed that our recommendation would be to revoke 3 months and to reinstate his probation.
Okay. Ms. Simpson, how has Mr. Rainey done on probation other than this situation?
He's not been revoked prior to probation.
Okay. Any issues? I mean, people cannot be revoked, but with Palm, there could have been.
He never completed his initial required community service hours, so that would be a condition that he needs to complete.
Okay. Okay. Oh, I remember this case. So you're supposed to stay away from the school, and you were supposed to do 120 hours of community service. Had Mr. Rainey done any?
Did Santa Claus just show up?
Says he only completed 5 hours.
2. Well, that leaves a bit left. Okay. Mr. Rainey, first tell me how you're doing having been hit by a car. I'm sorry that happened.
I'm doing so-so, going through therapy, learning how to walk, and use my left hand again.
Okay. What part of you got hurt the most?
The whole left side. Sir.
Whole left, so you got hit on the left side.
I had 2 major surgeries.
Ouch. Okay. And what is the prognosis? Should you be able to walk better in the future, or it's hard to tell?
It's about 2 or 3 more months. My bone on both arm and leg should be fully healed in about 3 or 4 more months.
Okay. Well, I'm sorry you went through that. So this address seems to be creating some trouble for you. I have the same address that everyone seems to have, which is 453 Wilson Mill Road. What is at that address?
Me and my dad stay.
Okay. Does your dad live there full time?
Yes, sir.
Okay, because the probation officer indicated that he or she, I think it's a she, left a letter there saying you got a report, and it doesn't sound like you got that letter.
I didn't get that letter, sir.
Okay. Did you have a phone at the time? This is back in June, so this is before you got.
I used to call my probation officer on my dad's phone.
Okay.
He'll call me on my phone.
Got it. Okay. But your probation officer at least had phone numbers for you. It might be your brother's phone or your dad's phone. Okay.
He always call me and let me know that he coming by, and I'll be there when he come by.
Got it. Okay. So it sounds like in the past it worked well. We just need to make sure it continues to work well. Doesn't seem like you're going to be getting out and about too much for a little while. But when you are released from jail, will you be going back to Wilson Mill Road?
Yes, sir.
All right. Okay. Any questions about anything?
No, sir.
All right. Ms. Wood, anything else on behalf of Mr. Rainey?
No, Your Honor.
All right. Mr. Rainey, I do find that you violated the terms and conditions of your probation. And while I understand the recommendation of 90 days rather than 60 days coming from the state and probation, given your medical condition right now, I think you will recuperate better at home rather than at the county jail. And so I will go with the 60 days. But you should know, if we're having to talk again soon because probation couldn't find you, it's not going to be just a few months. It'll be, you're showing us that probation doesn't work for you. So make sure your officer has good phone numbers, and maybe engage with the officer about when you say you sent a letter, what does that mean? Like, where'd you leave it? Was it on the front porch? Was it, I don't know if 453 Wilson is like townhomes, and maybe she put it in a different place, but ultimately it's on you to stay in touch with the officer and not the other way around. Okay?
All right.
All right. Any questions about any of that?
No.
No, I'm good,
All right.
Judge.
So I am revoking 60 days, reinstating the balance. And remember, you've got community service to do.
Yeah.
That doesn't mean right away with a walker, you have to be out there doing things, but that balance is not going away. It's an obligation you have. It's what you committed to when you entered your guilty plea. So as you get healthier, make sure that's part of your routine. Okay? Ms. Simpson, anything else?
Your probation officer has changed.
Oh.
And so I will get that information to you as soon as we are.
Yes, ma'am. Thank you.
Ms. Dilligard, anything else?
Nothing further, Judge.
Ms. Wood?
No, Your Honor, thank you.
All right, Mr. Rainey, you're going to be getting out soon. Take care of yourself.
Watch out for those cars.
I'm ready, doctor.
All right. We're going to cut and jump over to one that Josh found for us. He's found some great ones in the past. Let's see. It's going to be on City of Lake Forest Park. It's 3:20. This video. Hold on. We have to start at 1:57. Okay, here we go. All right, on this one, we're just here for Jonathan Schuster. Starts in just a couple of seconds here.
All right, that's everything for Mr. Saldavia. Thank you.
See ya.
Next, we can address Jonathan Schuster. This is for arraignment 4A05-25748.
Come on up, sir.
Schuster barefoot. Oh no, he's got.
You have his. Go ahead and have a seat, please. His rights at arraignment.
My honor. So, for the record, I've made this special visitation under duress pertaining to the matters of Jonathan Troy, Faifolea Somaliatoa Schuster. For I am beneficiary, I am sovereign, I am man. The flesh lives, the blood flows. I am a non-U.S. citizen, American national. I am sui juris imperfecta persona. I reserve all rights. I do not understand the status. And so I ask you, ma'am, what is your name? What is your nationality and what is your status?
What is your nationality?
I'm Judge Grant. I am a citizen. I'm the judge in this court. You are here subject to appropriate jurisdiction. So you are here for an arraignment. You've been charged with a crime. Today, you will be asked to enter a plea.
Ma'am, I object because a citizen cannot sit a bench, ma'am.
So I'm going to go through the information. It looks like you have been charged with driving with a suspended license, driving without a required ignition interlock device, refusal to comply, not having proper registration on the vehicle, expired over 2 months. And then there was also a driving violation. Wheels were off the roadway. Last two are infractions. So,
ma'am, jurisdiction cannot be proven unless status is established. You have not established status. And so if you cannot do that, I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case with prejudice.
that would be denied. So I am going to, at this time, review for probable cause.
Object. Again, I challenge the jurisdiction, and jurisdiction must be proven.
It's not going to happen today.
Jurisdiction must be proven.
To hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody. And I will hear from the prosecutor as to that.
And if you violate my rights even further, ma'am, as well as the officer and the sergeant that
Gonna
violated
sue
my
them.
rights, who are also going to be getting sued. It would just add to that. And I
You
don't
can do
think
that,
that
but
you
right
need,
now.
you need to go that route.
While I review this incident report.
This never works.
Okay, so this is authored by Brandon Carlsrud, signed under penalty of perjury.
He's threatened to sue the officer, threatened to sue the judge, wants to know the judge's nationality.
All right, I do find probable cause with the charges. I will be entering not guilty, please.
Ma'am, you cannot practice law from the bench. I object.
Noted.
You cannot
Noted.
enter a plea for somebody. That is, practicing bench from the
Unless you
law.
want to enter a plea of guilty, today there'll be a plea of not guilty. Understand you are objecting.
Ma'am, I object. I challenge the jurisdiction. Jurisdiction has not been proven. Status has not been proven or established. And once again, you haven't even established, your nationality or your status. I am a non-U.S. citizen, American national by way of America Samoa. I reserve all my rights.
Is this something that we need to consider a competency evaluation for?
We may need to consider ordering ability to proceed, but
Mike, do you want to check his head?
to look at ADR.
Once again, you got to give him credit. He has no papers. He's got it in his head. He's done his homework. Unfortunately, he did his homework on the internet, and he went to that
It looks
site.
like you have a driver's license that recently expired.
How'd you get that driver's license? Do you have a change of heart?
To question my competency because I'm establishing status and asking you to prove jurisdiction is outrageous. And so, again, if jurisdiction cannot be proven, I move to dismiss this with prejudice based on the grounds that you cannot prove jurisdiction.
All right, I've reviewed this. You were driving in the city of Lake Forest Park. You were violating
Again,
laws.
I was not driving. I have rights.
You were behind.
And my rights were violated. My rights were violated. My right to travel freely unencumbered was violated. There was no emergency in which the officer needed to put on his red and blue lights. And so, again, if status cannot be set, jurisdiction cannot be proven, I move to dismiss this matter with prejudice.
That's denied. So you've made your record. Right now, I'm going to directly appoint counsel from the bench. Ms. McDonald.
Again, I am sui juris in propria persona. I stand on my 2 feet. I'm in my proper person. And so I reserve all my rights.
I understand that, and I've acknowledged that. I'm not dismissing your case today. I'm going to hear from Ms. McDonald as to the city's position on release.
Yes, Your Honor, I am going to be asking that the bail remain the same. It looks like it's currently set at $2,000. I do have some concern regarding his willingness and ability to reappear if he was released on his own recognizance, as well as concern about community safety and risk of reoffending, given his temperament in the court today.
And Your Honor, Mr. Schuster would ask the court to release him on his own recognizance. These are not violent offenses. I don't see that he has any convictions for violent offenses. There was an assault from 2021 that was dismissed. He may have a view of the law that is different than the city's, but that in itself does not indicate that he won't come to court or that he would
think?
In any way try to subvert court proceedings. So we'd ask the court to release him on standard conditions.
Well, the court can consider whether or not Mr. Schuster is likely to reappear for future court hearings. What I hear from him today is that he completely objects to this court having any jurisdiction. I don't have a good faith basis that Mr. Schuster will return if I were to release him. I do see that he has a prior conviction for DUI. He's on a deferred prosecution at this time in Seattle Municipal Court. He's not complying with conditions if he's driving without a license and driving without a required ignition interlock device. Also, indication that Mr. Schuster will not abide the court's orders to appear on his promise. I want to look at the Seattle municipal case and see when he's next scheduled to appear.
Like you had mentioned too, in 2021, same situation, or not same situation, a situation occurred in which they tried to charge me. They didn't have jurisdiction. It was dismissed. And again, I don't want any charges against me because I do have the deferral, which would obviously violate that deferral. And so
you seen this worked before?
I will make any visitations, special visitations to the court to handle any matters pertaining to Jonathan Troy Faifaleaso Malietoa Schuster. I'm a
Can you spell
man,
that?
I'm free, and I
The
want
blood
it to stay
flows?
that way.
I do see it looks like he's got at least 3 prior warrants. He has 2 priors out of Benton County, 1 out of Lower Kittitas. The previous warrants history.
And throughout this process of going to courts, I've had to learn a lot. And so I know it's no game to just not show and make visitations. That's not what I want to do.
Make visitations.
And
I'm here for my visitation.
Again, jurisdiction does need to be proven, whether it's today or another date. And if you want to violate my rights even further by not releasing me on my own recognizance, ma'am, was it Jennifer Grant? Then, like I had mentioned earlier, you, along with the officer and sergeant, who are already going to be getting sued, I mean,
will be sued again.
There's no need to add you as well, especially when you know the law.
I don't see another date set until February 12th of 2025 in the Seattle.
In Seattle Municipal Court?
Yeah.
So this is the first appearance that we have from him. We've got another one after this that might turn it up a notch.
Well, Mr. Schuster, I have to do what I believe is appropriate in this case, and that is to set bail. And any threats to sue me or to take any action against me, I can't be swayed by that. So
It's not a threat. It's just what it is. Because my rights have been violated, and if my rights are going to be furthermore violated.
$2,000. I do not believe that you will respond to the court's order to come back. I do base that upon the conduct in this case, as well as the prior FTA history. So bail will be $2,000. If you're able to post bail, you are to return for your next court date. You are to have no criminal law violations. You're not to drive unless you have a valid license and insurance. And
when are you setting that court date, Miss?
Required by the Department of Licensing. You will be represented because I'm going to assign counsel.
I am sui juris in propria persona. I present myself. I don't need to be represented by anybody. I stand on my own 2 feet.
These are criminal charges.
Yes, but
that
those feet are
have
shackled.
significant consequences for you. So it's in your best interest to have counsel.
Again, I
assist you.
stand on my own 2 feet. I do not need to be represented by anybody. I present myself, sui juris and propria persona.
Well, if you want to be your own counsel, you'll have to go through a full colloquy and waive all your rights to have representation. It's your constitutional right.
I do not accept being represented by anybody. Again, I present myself. I am beneficiary. I am sovereign. I am an American national, a non-U.S. citizen American national by way of America Samoa, like I had mentioned earlier. I reserve my rights, and I do not need to be represented by anybody.
It's like to mispronounce words.
The time for trial expiration is 8/9/24.
Again, if you are practicing law from the bench and putting a plea in for me, I object to that. You cannot practice law from the bench.
Next court date will be, let's see.
We need to find out
We
if
want to
this
try for
actually
next
worked for him in
Wednesday
2021.
or even the week after that.
Well, next Wednesday's a holiday, so the 18th, which is pretty full. So I was going to set this on June 24th. That's 2 weeks out.
Yeah, that works.
So for the record, you have not established
status.
You have not proven jurisdiction, and you're denying my rights. Is that correct?
I don't know what you think would establish my status, but I do have status to sit in this court.
You are a U.S. citizen. A U.S. citizen cannot sit a bench.
Well, we'll see you next time.
Sorry for your next court date.
You're asking me to sign something that...
Thanks, Katie. Thanks, Josh.
You pleaded for me. Is that correct?
I'm giving you notice of the conditions that I have set as well as bail.
You said yes, you
noting that
pleaded
I
for
found
me?
Probable cause. If you are able to post that bail and get out of custody, those are my expectations that you will come back on that court date and that you will abide by the conditions that I have imposed. Those are being ordered today. So that is what's happening today. And we are giving you that notice. You can refuse to sign that notice, and we'll note that you were provided a copy in writing and that you refused to sign.
I do not understand.
Which part of it do you not understand that you have a
I do not understand how you can practice law from the bench.
I'm the judge and I am setting the conditions.
Well, you also entered a plea for me, correct?
What we're doing at arraignment is the plea is being entered. You're not pleading guilty. So on your behalf, I'm entering a not guilty plea.
So correct, you are pleading for me,
There's
correct?
2 pleas.
And if you
Not
plead for
guilty
me,
or
you're
guilty.
practicing law from the bench. You cannot practice law from the bench, so I object.
I'm going to give you that piece of paper and we're done with your hearing today. We will see you in 2 weeks. Okay?
Jennifer Grant, you will be
sued.
Taken further.
Yeah, I would get back on the internet and
All right. Do we
ask
have
for your
any
money back
information on Mr.
because it
Phillips?
did
Were
not
you able
work.
to confirm treatment, Ms. Eber?
Okay. There's the first one. Now we have another for him, and I guess he's going to be back tomorrow as well. My goodness. See if I can pull this one up. 218.50. It starts at 2247. Okay.
Showed up in person?
No one's knocked on the door.
Everybody knows readiness is zero.
Well, I mean, we all do, but sometimes they do show up. There's nobody in the lobby.
Yeah, there is somebody in the lobby.
We will figure out who's in the lobby.
It's Partida Garcia.
Oh, appears to be Mr. Partida Garcia.
So we just need to have him log on to the there we go.
Here we go.
Thank you.
Okay.
There's the
So I
lobby.
assume-
Basler, I'll pull you into a breakout room here.
Okay.
If I can just, I might need your assistance.
Why did courts not let you show your chain?
How to get into the breakout room.
Why can't you show your bling at court?
If you could interpret, Mr. Partida, I've sent you an invitation to a private room where we can discuss your case.
Señor Partida, le mandé una invitación para meterse en un cuarto privado para que podamos hablar sobre su caso.
Do you see a little window? There we go.
Veo
Okay.
una ventanita y está bien.
Thank you, Mr. Interpreter.
Welcome.
A moment. So I think are you ready on Mr. Schuster's case, Ms. McDonald?
Well, Mr. Schuster, just to give Your Honor a little bit of background on this one, Mr. Schuster is representing himself. The court has previously gone through the waiver of right to counsel. When we were here, I believe the last hearing, Mr. Schuster gave an indication that he wanted to resolve these matters. So I have drafted a plea form with the city's offer on it. I just am not sure how to get it to him. I can certainly send it to him in the chat. I just don't know if he has the ability to download that and sign it if in that respect. So,
hi, ma'am. How are you today?
Hold on a second. So let's the preliminary matter. This is Jonathan Schuster, 4A0525748.
Quick, get something on the record, Jonathan.
So it sounds like Ms. McDonald's trying to get you some documents, Mr. Schuster.
Yeah, so for the record, I reserve all rights and retain them. I am making a special visitation for the matters pertaining to Jonathan Schuster, for I am the beneficiary. I had mailed out some paperwork over to the prosecution as well as submitted it to the court. Were you able, have you received those, ma'am?
So I've received 2 motions from Mr. Schuster. Have you?
Yeah, the 2 motions as well as the affidavit, as well as the certified copy of the, so you got that paperwork. Were you able to read it?
I have 2 motions. One was, both were received today.
Right. You should have received an affidavit as well.
I don't see any affidavits.
It's on the back.
The affidavit was received at the same time that the motions were submitted. And so.
And I don't know that we've received anything. I'm checking with my office right now, but I don't see anything in our files.
I emailed to Ms. McDonald this morning.
You did, I'm sorry, what, Madam Clerk?
I emailed to you a copy of the first motion to dismiss and the affidavit of truth, it's called.
Affidavit of proof.
Yep, there was a motion for dismissal as well as a motion for show cause, as well as the affidavits.
Hold on, Mr. Schuster. Hold on, Mr.
So those were sent over.
Hold on, Mr. Schuster.
As well as submitted to the court.
Mr. Schuster, hold on a second. Ms. McDonald's getting caught up. I do have your affidavit.
I just wanted to make sure I said that. Thank you.
Madam Clerk, did you send that to my email or did you send it to the office email? Because I don't have anything from you today. Except the orders from Mr. Bailey Garrison and the borrow out information from Mr. Goodwin.
Okay, if you need time to get that, that's fine. I just require that due process is, that we.
Okay, hold on, Mr. Schuster. There's going to be plenty
Require
of
that
time
we
for you
do
to talk.
process.
Yes. Thank you.
We can feel it sobbing in the air tonight. Oh, I can feel it sobbing in the air tonight.
Madam Clerk,
Hold
sending
on.
it again to your email, Ms. McDonald.
It's 11:06.
Ms. McDonald's
Also,
background.
The prosecution. I've never received anything from you as well. But there is
we're trying to get you.
An email on for contact information, so you can send that over via email if you have anything to send to me.
We sent you discovery at both addresses that you gave to the court. So they were physically copies because there's digital evidence as well?
Well, I just have never received anything from you.
Well, it went out to your mail, so I don't know what to tell you about that.
Did you check, Mr. Schuster?
I mean, I haven't received anything.
That's not my question. My question is, are you checking your mail regularly?
Oh, I definitely look out for mail regularly.
Okay, and does the court have your current address?
So he updated it, Your Honor. We actually had this situation issue a couple of weeks ago, or actually almost a month ago, where we had sent out full discovery to the defendant, and then he indicated that that wasn't his address. So we sent out another packet of full discovery to him to the address that he updated. Let's see, the one on California
Avenue.
You gave us on January 27, 600-01 in Seattle.
You're talking about on January 27th when the judge denied subject matter jurisdiction that day?
So the address that you gave to the court on January 27th was the 600 Southwest apartment G20. So
the same day that
that was
Mr. Schuster
denied subject matter jurisdiction.
Mr. Schuster, is that the address you gave on January 27th?
I don't recall, but I do have, somewhere she can send it to. So
well, we're not going to play the game of you updating your address every court date so that you can avoid service of discovery.
I'm just letting you know that I didn't receive it, and I don't recall. So I'm giving you an address, but
you recognize that address?
Which address?
Can you read that one more time, Ms. McDonald?
Yes, the address on January 27th that he requested discovery go out to was 6 G201 in Seattle. The one prior to that he requested was 10 Street, apartment C in Kennewick, Washington. All discovery was sent to both of those addresses.
Do you have the ability to get mail at the Kenyon Street address, Mr. Schuster?
No, I'm not sure why she sent that there.
Because that's the address you gave the court at the end of January.
Well, in January, the judge had denied subject matter jurisdiction, and so the matter should have been dismissed anyways.
So the judge denied your motion to dismiss for lack of subject matter jurisdiction. The court found that
she did. It was on the record. She denied subject matter jurisdiction. She didn't deny my motion. That wasn't until later. But regardless, you did receive the two motions as well as the affidavit today. Is that correct, ma'am?
I did. Did Ms. McDonald? Have you gotten that yet?
I just
perfect. Have you had a chance to read over that, Miss?
So obviously, Ms. McDonald has not had a chance to read over it.
Oh, I was referring to you, ma'am.
Okay, Mr. Schuster, let me talk. So do you remember doing the waiver of counsel on December 16th, where you said you wanted to go forward representing yourself?
Well, from the very beginning of this
Remember
matter,
signing this piece of paper saying you were representing yourself?
From the beginning.
That's not my question, Mr. Schuster.
I'm answering your question. I would like
I don't want a narrative. Yes or no? Do you remember signing this piece of paper?
I don't recall.
Okay.
I don't know what paper you're showing me.
You're on this piece of paper.
I'm not sure what paper you're showing me because it's very far from the camera and it's just very hard to read because it's blurry from this angle.
So let me read it to you.
So I don't recall.
On December 16th, 2024, you went through a colloquy with Judge Grant. During that colloquy, you engaged in a series of questions about your familiarity with the rules of criminal procedure, criminal courts in general, the Constitution, and so on. At the end of that, you indicated that you have read and completed the form, you requested the court to allow you to represent yourself, and you signed it and dated it and noted you reserve all rights. On that form, one of the things that you are asked to do and acknowledge and understand is that you will be treated as though you are an attorney and you will be expected to follow the court rules as though you were an attorney. One of those rules that you're expected to follow is the Lake Forest Park Municipal Court local rules around how to file and the proper notice of filing motions. The local court rule requires that if it's a motion that is not set on the date of trial, that the expectation will be that you give 21 days notice and properly serve the other party. these motions dropped off, emailed, whatever to the court the day of and the day before the hearing are not properly noted under the local court rules. Nonetheless,
This isn't the trial,
nonetheless, I am going to let you know that I have reviewed these motions. And if it's okay with you, Ms. McDonald, I'm going to go ahead and let Mr. Schuster know that I've reviewed these motions. There's two of them, a motion to dismiss for lack of subject matter jurisdiction, and another motion that is essentially a show cause motion for the prosecutor to appear and show cause as to why there is subject matter jurisdiction in this case. And what I want to tell you on the record right now is that Lake Forest Park Municipal Court is authorized to hear misdemeanor and gross misdemeanor cases along with violations of local ordinances. We are not authorized to hear federal matters. Your assertion that we are not authorized to hear federal matters is absolutely correct. Nonetheless, these are not federal matters. Federal courts do not have exclusive jurisdiction over travel and driving offenses. Proceeding with this case is not a due process violation of the Washington or the federal Constitution, and so I'm going to deny your motion to dismiss for lack of subject matter jurisdiction. Turning to your motion for show cause, you cite an RCW that outlines district court jurisdiction, which is not even applicable in this case, but nonetheless, Lake Forest Park Municipal Court is the correct venue for misdemeanor and gross misdemeanor driving offenses that occur in Lake Forest Park, Washington. The constitutional right to travel is not abridged by states and municipalities' adoption of regulations concerning driving privileges, and therefore I'm going to deny your motion for show cause against the prosecution. I'm also denying your motion to dismiss in that motion, finding that this court, again, does have subject matter jurisdiction in this case will proceed. So those motions are denied.
Now we've addressed subject matter
I am
jurisdiction.
also not really interested in hearing that you have yet a third new address for Ms. McDonald to send discovery to. So at this point,
it was never a third. In the beginning, you had the correct address. It's no longer the correct address.
Then it's not the correct address. If it's no longer correct, then it's not correct. You've given a
as of literally not that long ago.
So when did the Kenyon Street address become a bad address?
I want to say
about 10 minutes ago when I left.
Within the last month-ish.
So sometime after January 27th, the Kenyon Street address became a bad address, correct?
And you said the motion to show cause was denied on what grounds?
It's not been properly filed. You did not comply with the court rules, but even allowing you to file and reviewing it, there's no basis for me to grant it. It is not legally sufficient to grant your motion.
To prove that you have subject matter jurisdiction?
So first of all, the prosecutor doesn't have to prove that the court has subject matter jurisdiction. I am ruling and telling you that this court does have subject matter jurisdiction for the reasons I previously stated.
And this is a court of record, correct?
Is a court of record.
You said this is a court of record?
It certainly is a court of record.
I see.
We are on the record now.
I see. Now I get it.
So that being said, it sounds like Ms. McDonald has a plea offer to send you if you want to entertain that. Would you like her to send you that plea offer? And if so, what is the best way for her to do that?
Well, she's allowed to send me whatever she would like, but I do have an address since I want to make sure that, everybody has the correct information.
What is your current correct address?
The mailing address would be 231. I believe that's Southwest. D.
Unit D?
I don't know how they label it, but it's just D is what I've seen. And then that's Seattle, Washington, 98116.
How do you live there but not know how they label it?
Oh, I didn't say I live there. I just get mail there.
Is that a friend's house? What is that?
Family.
What was that?
family.
He's humming. Oh my goodness.
And so, just so I'm clear,
subject matter jurisdiction.
You're saying that the right to travel in privacy is not a federal matter, and that you're saying that you have the jurisdiction to hear a matter that involves this.
I am saying that there are federal constitutional rights, there are state constitutional rights. Sometimes one, sometimes both, sometimes none are implicated in a criminal case. I'm saying that the Lake Forest Park Municipal Court has jurisdiction over driving offenses that are misdemeanors and gross misdemeanors occurring in the city of Lake Forest Park, Washington, and that the fact that there are federal constitutional rights associated with travel does not preclude the city of Lake Forest Park from filing or prosecuting these cases.
Well, so the right to move freely, which is part of liberty and, a right, because no person shall be deprived of life, liberty, or property. You're saying that isn't a federal matter?
I'm saying that there are multiple layers of jurisdiction that involve travel, and that the fact that there are federal rights around travel does not preclude Lake Forest Park Municipal Court from enforcing state and local ordinances. So what do you want to do on your case today, Mr. Schuster? Is it your intention to go to trial next week? Is it your intention to entertain a plea offer from Ms. McDonald?
Well, I just want the court to know that any judgment issued without proper subject matter jurisdiction is void and may be challenged at any time.
And you're free to appeal any ruling from this court.
Authority to hear this case, and proceeding further would result in an unenforceable judgment. Therefore, this is what must be dismissed.
You are free to appeal any ruling this court makes. You can certainly, since you are
most definitely
how to do that. Nonetheless, we have to figure out what you're doing today on your case. It's your readiness hearing, where you tell us if you want to go to trial next week or if you want to entertain a plea offer from Ms. McDonald.
Well, as I've stated, this case should be moved to the proper courtroom, which it's not.
In the proper courtroom, and that's not happening. And Mr.
Schuster, if it's not transferred, I do. It should be dismissed.
And not entertaining further motions to dismiss. Ms. McDonald, go ahead.
Yes, and Mr. Schuster, I sent to you in the chat because that is the only way for me to get that to you right now.
Oh no, you have my email. You got the information on the motions there. So you have the email listed above. I don't really know how to use Zoom like that, and so sending anything over through chat like this is just it's difficult. So email would be the best way if you want to get that to me faster. But of course, you have an address now that I'd be able to get the mail that you're saying you've sent already, but no worries. So
I'm using Zoom the same way we used it at the last hearing when we sent you documents and you were able to chat back and forth with me. So it's in that chat.
We didn't have a back and forth.
We did.
Chat. No, we didn't.
So there is a document in the chat for you to open and take a look at, and that is the city's plea offer. We are agreeing to dismiss 2 charges for a plea to 1 with a credit for time served recommendation. So if you'd like
as I've stated, you can email it so that I can properly see it, because that's the best way for me to do it quickly.
He's not gonna get email
because I don't really know how to use this chat function in Zoom.
Ms. McDonald, do you have the ability to email it to him?
I'm looking for the email.
Yep, it's at the top for the motion to show cause, as well as the bottom of the motion for dismissal.
She doesn't have those.
But, I can also just read it to you if you'd like that.
If you can put that into the chat so I can make sure that I don't spell it wrong, that would be great.
Well, as I've told you, I don't know how to use the chat.
All right, so we're streaming live to YouTube, Mr. Schuster. Would you like to read your email for anyone who's watching YouTube to listen to and hear?
I mean, they can email me. I don't mind.
Okay, so he's given permission. I'm going to let you guys
spell out your email for Ms. McDonald.
Do you know how to spell my last name, Ms. McDonald?
Please just spell it out. Let's just be as clear as possible.
The whole
it'd be my last name .jon@icloud.com.
Can you spell your last name for her?
Yeah. Are you ready, Miss McDonald?
Yes, I am.
Okay.
Hard. No, you're not. You're not ready yet.
SCH.
Okay.
Can you hear me?
Yes, I can.
Oh, okay. I wasn't sure if you could hear me. I know we've had trouble communicating over Zoom because sometimes you can't hear. But SCH, USTER.
Okay.
You got that?
Yes.
Oh, okay. So
Is it-
my last name, Jon, Jon.
Okay.
You got that?
Yes.
Oh, okay. At iCloud.com.
Wow.
It's actually pretty ironic that you say that about the email, but then mailing addresses are said out loud too. So that's just kind of ironic
So far,
that you would mention that.
yeah. Well,
But
as I said at the beginning,
nonetheless, it's okay.
of court, everything's being broadcast on YouTube, but
Oh, I know.
now we
But
need to
nonetheless,
respond to the fact that you have changed your address repeatedly. Ms.
nonetheless,
McDonald
that's
is
just
emailing you.
ironic.
Ms. McDonald is emailing you a copy of a plea offer.
Cool. You said you were going to send that in the mail as well. So, or information in the mail?
It's not coming in the mail. It's coming via email right now. You have the opportunity to
I'm
review
talking
it
about
right now.
the other information she was.
No, that's already been sent in the mail. You need to go to wherever those addresses were to get your discovery. The discovery was sent out on February 10th, approximately a week and a half after you gave that address on the record.
On the record when the judge denied subject matter jurisdiction?
When you were in court on the record.
On that day when she said she denied subject matter jurisdiction. Yes, I remember her denying subject matter jurisdiction.
You also gave an address. Ms. McDonald sent your discovery to that address about a week later.
So you're saying that you can't send that to the proper address, Ms. McDonald?
We've already sent it to both addresses that you've provided to the court.
What she's saying is you can't come to court once a month, change the address, have her send out discovery, and then come back a month later and say that wasn't the right address to send it to.
That was my
So
plan.
you're not going to send it to the proper address. Okay.
Did that get sent, Ms. McDonald?
Yes, it did.
So, Mr. Schuster, you should be receiving an email from Ms. McDonald. That is Ms. McDonald's plea offer. I'm going to ask that you review that and then let us know if you'd like to accept that today or if you'd like to move forward with trial.
Well, I'm on the Zoom right now.
Right.
And so my email, I'm using the same.
Camera and review your email.
What's that?
You can go off camera and review your email.
Okay, so I can just get off and then come back on?
I would prefer if you'd stay signed on to Zoom and just go off of camera and review your email.
Okay. Let me see if I can do this without getting off. Because as I've stated, I don't really know how to use Zoom like that.
If you get disconnected, you know how to get back on it.
Okay. One moment.
So, I've not seen this before. Any bets on whether or not he has trouble with his email? Oh, you're back. Guessing it didn't come through.
Can you mute yourself, Mr. Schuster, and turn your camera off to read your email?
Oh, I saw that Carmen had sent something over.
I guess you need to open it and review it.
Oh, it says what you had said on the record, correct?
No, it's an entire form. It's about, see how many pages that is? About 8 pages.
He is not reading it.
Can you mute yourself and take yourself off video while you review that, Mr. Schuster?
I think so. Let me see if I can do this correctly.
It's a lot easier to do that on Zoom than it is to look up pro se lawyering SovSit stuff on the internet. Every part of me wants the judge to he's doing nothing. He's making
why don't we
direct
go off
eye
the
contact.
record?
He's making direct eye contact. He's not opening anything. Yeah. When we come back, he will not have done a dang thing. I'm hoping that somewhere along this, that he violates the judge's order.
Mr. Schuster, are you reading the document that Ms. McDonald sent to you?
Sends the sheriff out. Oh, I'm muted.
Are you reviewing the document that Ms. McDonald sent to you?
Okay, cool. Got it off mute. Oh, so I see everything that you've sent over. Obviously, I'd probably have to look at it longer to make sure I
asking you
carefully.
I'm asking you to do that now. We're going to go back on the record.
Oh, okay. It just might take some time. I mean, I've gotten through some of it, but for me to understand what's going on, I definitely would have to read it. I don't know if you have enough time for all of that, but if you do, I don't mind, taking the time to fully get into it.
Ms. McDonald, you're on mute.
It's because I was saying bad words, she says.
If he's asking for more time to go over the city's offer and to consider that, I don't have an objection to continuing the matter if he agrees to waive speedy trial.
Oh, no.
Well, if you don't wish to waive speedy trial, then
If she doesn't want to give me more time, then I guess we just got to.
The problem is, Mr. Schuster, you have to be brought to trial within 90 days of your arraignment date. And so your trial is scheduled for next week. But if you want to take advantage of the city's
on
offer,
the 11th.
Right. If you want to take advantage of
9 a.m.
If you want to take advantage of the city's offer and you want more time to review it, unfortunately, you would need to set over that trial date.
Well, I can counter to you right now if you'd like.
I'm happy to go in a breakout room.
I don't know what that means.
I don't know that these are necessarily conversations to have on the record, but
if you want to go into a breakout room, in other words, go into a separate Zoom room with just Ms. McDonald so you can discuss her offer, I'm happy to allow you to do that right now.
Okay, how does that work? How do we do that on Zoom?
I can do that. I can put you in a breakout room. You'll get an invitation.
Do I need it? Okay.
Pop up on your screen for you to accept.
Okay, so just wait until something pops up.
Yep, I'm going to put you in there right now. It will be into room 1.
Prosecutor McDonald.
How would I come back, though?
There will be a button on the bottom right that says leave breakout room and back to main session.
Okay, so it says join breakout room. Prosecutor McDonald is inviting you to join room 1. So I just click join?
Yes, and I'll be in there.
All right.
Okay. All right. Wish me luck.
Wish me luck. I'm going in. There goes Prosecutor McDonald. Oh my goodness. The wish me luck. The judge is chuckling to herself. Oh my goodness. We're going to see if we can fast forward just a little bit until they come back, because look. Little break. Okay, here we're back. 10 seconds. Nice courtroom. Judge turned the lights off. Get a little shut eye. Waiting for the. Oh, here we go. Wake up, Judge. We're back. Turn on the lights. Fire up the cameras. There we go.
We're just waiting for Madam Clerk to come back.
Hey, Judge, can you hear me?
I can, Mr. Schuster.
So 9 a.m. the 11th, is that what it is?
We're not on the record and we don't have a clerk yet, so.
Oh, okay.
So
If we're not on the record, I guess I could ask this.
No.
Are you going to be there on the 11th, or is your higher judge or higher up going to be the one who's there?
Should be Judge Grant.
Oh, okay. I was expecting to see her today. That's too bad.
She can't wait to see you, Mr. Schuster. She just can't wait.
You said we're just waiting for the clerk?
We are. We're not on the record.
Oh, okay, cool.
That's the only song you know. It's a Soft anthem. Okay. His arrogance is palpable. There's the song.
Schuster is back.
Comes the clerk. Once she's ready, we'll be on the record, and then do we need a soft anthem song?
So we're back on the record with Jonathan Schuster for A0525748. Mr. Schuster had an opportunity to speak with Ms. McDonald in the breakout room. And Ms. McDonald, where are we?
Yes, Your Honor. I'm a little bit concerned because it didn't appear that Mr. Schuster was, and I was kind of having a hard time discerning whether or not it was a willingness or an ability to track the conversation.
Oh, objection. I definitely have the ability to have a conversation and track what's going on. I offered her a counter and she didn't want to take it. And so that's where we are, ma'am.
So I do have some concerns there. Also, Your Honor, I did just pull up his criminal history. It appears that he does have an active warrant out for his arrest for a DUI.
Active warrant?
SMC bench warrant from 2/14/25?
Yes, that is the one. So I have a couple of concerns. The concern is the defendant is saying he doesn't have discovery. He has not read the reports. I asked him several times if he was prepared to proceed to trial on all three charges next week.
And I told her 9 o'clock on the 11th, I will be there.
So,
Mr. Schuster, that you're intending to go to trial without.
Right. And you're saying there's an open warrant. It was at King County. Is that who that's with?
So, Mr. Schuster, the Seattle Municipal Court issued a bench warrant for $5,000 on February 14th, 2025.
Valentine's Day.
Okay. And so I'll need to obviously reach out to them so that we can get that quashed and taken care of.
Quashed.
That is true. You will need to do that.
Which I will do as soon as we're done here.
A warrant for my Valentine.
If we're having another hearing next week, is that you will have done that before the next hearing.
Oh, 100%. No need to be walking around with warrants. That is unacceptable.
So, Ms. McDonald, are you raising 1077?
Well, I would ask that the court engage in a colloquy because I like I said, I was having a difficult time assessing that because I don't know if it's an inability to track it
Objection.
appropriately or if it's unwillingness.
So Ms. McDonald is asking that I ask you some questions to make sure you're able to proceed.
Objection, Your Honor.
Mr. Schuster, there's nothing to object
It's been on the record. I'm ready for whatever we need to do on the 11th outside of quashing this warrant that I just recently found out, as you've said it. I didn't even know that was a thing. So now I have to just take care of that. The 11th, I will be there at 9 a.m.
So, Mr. Schuster, I'm going to ask you some questions. First and foremost, do you know what happens at a trial?
Do I know what happens at a trial? Yes.
Can you describe that to me?
What happens at a trial, where we meet and go over the facts and determine whether or not that I will be charged with the allegations against me.
So who decides whether you're guilty of the allegations against you?
Well, of course, it's a trial jury.
So who's on a jury?
Well, my people. I mean, it's the people of, it's the people. Obviously, it's a jury trial.
Do you know the difference between a bench trial and a jury trial?
Yes.
What's the difference?
One, there's people who make the decision, and one, the bench makes the decision.
And who's the bench?
Well, I believe I'm speaking with her currently.
So the judge is the bench.
The magistrate.
What are you charged with right now?
You want me to say it off my memory or read the actual charges from the, because I have my paper. I can go get it real quick. I
don't need you to read it to me. I need you to tell me to the best of your ability what you're charged.
Oh, okay. Yeah. You're charging me with, or the allegations are driving with a license suspended, 3rd degree, no interlock device, failure to comply. Is that correct?
Correct.
Yes.
Do you know what the maximum penalty for each of those charges is?
Not off the top of my head. No way. I'd have to look at my notes.
Do you understand that DWS 3rd degree is a misdemeanor punishable by 90 days in jail and a $1,000 fine?
I understand the allegations against me, correct.
And that there's also a gross misdemeanor punishable by up to 364 days in jail and a $5,000 fine?
I do understand the allegations against me.
What would the city have to prove if he went to trial?
That the allegations are true. They'd have to have an injured party show that the allegations are true. And of course, they'd be able to present their beliefs over to the jury, and the jury decides. I'm not sure what we're doing here. I'm
asking you questions about the trial process to make sure that you understand the trial process.
Well, I have the right to present myself in court, and that's what I'd like to do.
Ms. McDonald, I'm not getting enough to raise 1077 at this point. I do understand your concerns.
Right.
I have concerns over Prosecutor McDonald and her ability to understand what's going on, but that's okay. I'm not going to raise any challenges or anything against that. I just want that noted. But regardless, I did give her a counteroffer, which was very reasonable. She declined, and so the next step would be, for this court would be the 11th at 9 a.m. Is that correct? Is that the right time?
That's correct. Ms. McDonald, do you have the ability to send over the electronic discovery to the courthouse for Mr. Schuster to pick up?
So we would have to, so the electronic discovery, we have the body worn camera and all of that information that had to be burned onto CDs and sent to him because it's too large to send.
You said CDs?
Email. So that was all sent out to his address. We would have to redo all of
CDs, you said?
Yes.
Some of the body worn cameras on CDs because it's too large to send any other way, Mr. Schuster.
You still use CDs? Is that what that is wild?
Well, you are held to the same standard as attorneys, and attorneys are expected to.
I'm just surprised that you still use CDs.
Is there anyone that your office could ABC Legal or something like that, that your office could get that over here quicker than the US mail?
Well, we would certainly be able to bring it to our office. Isn't that far from the courthouse, so it's not a difficulty in the transportation. It's just it would take my office probably the better part of the afternoon or tomorrow morning to get all of those burned to another set of CDs, because there's several.
So if I ordered that your office bring a set of discovery here for Mr. Schuster to pick up after 10 a.m. on Friday, would that be doable?
I would think so.
Okay, so Mr. Schuster, I'm going to have Ms. McDonald's office make you another copy of the discovery, burn the electronic medium onto CDs, and it's going to be available for you here at the court window after 10 a.m. on Friday. That is going to be the only additional discovery that you get. You need to find a way without driving to get here or get someone here to pick that up for you. That will be the only additional copy of the discovery for you. We'll be here at the courthouse for you to retrieve. The courthouse is closed on Saturdays and Sundays. So if you want to prepare for your trial, I recommend that you come Friday after 10 a.m. to do so.
And I'm wondering if we can just pass this for a moment so that Mr. Schuster, I would ask that he read the plea form through in its entirety, because I think that does impart some of the things that he needs to take into consideration, which I don't think that he's necessarily considered while we take the plea on the Partida Garcia matter.
I'm ready to proceed to trial on the 11th. Outside of quashing the warrant with, you said it was Seattle Municipal or King County?
Seattle Municipal Court.
Seattle Municipal. Outside of quashing that warrant, I am ready. I do have one question though.
I quash warrants all the time.
A criminal matter. So who was the injured party exactly?
The City of Lake Forest Park has filed charges.
City of Lake Forest Park. Okay, and they'll be present at the trial. I'll be able to face them.
They are represented by Ms. McDonald's office.
So the city is the plaintiff as well as the judge. Is that what you're saying?
The city is not the judge.
Lake Forest Park is not the magistrate for this matter?
Lake Forest Park is the municipality in which this court takes place. Judge Grant will likely be here next week. She is the judge. She does not represent the city. The city is represented by Ms. McDonald's office.
So the judge doesn't work for the city at all, is what you're saying?
She is a neutral arbiter of matters. She is not representing the city.
So she doesn't work for the city?
No, she works for the courts and the court system.
Ah, okay. And during trial, the prosecution will be able to bring the injured party forward, correct?
During trial, the prosecutor will be afforded the opportunity to bring forth its witnesses. I suspect that will be.
No, I'm saying the injured party.
I'm talking, Mr. Schuster. Okay.
Oh, I hear you. I just wanted to make sure it was clear.
The prosecutor has the ability to bring forward its witnesses. They have the right to cross-examine any witnesses that you bring forward. You are allowed to bring forward witnesses at no expense to you. You do have to comply with the court rules in terms of giving Ms. McDonald notice of any witnesses that you intend to call. So you can't show up on the day of trial having not notified her of potential witnesses and suddenly witnesses on her.
Okay, I guess I wasn't clear when I asked you, because I wasn't asking about witnesses. I was asking about the injured party.
There doesn't have to be a named injured party. The allegation.
Well, I have the right to face
You have the right to
face the injured party who's making these allegations against me.
You have the right to present a case.
She'll be able to
stop. You have the right to present a case on your own behalf. You have the right to hear and call witnesses at no expense to you. You have the right to question the city's witnesses. Okay, you have the right to cross-examine their witnesses, but
I also have the right to face somebody who's alleging
injured party, which is what you're getting at.
Well, I mean, in a criminal matter, there definitely needs to be an injured party.
Your Honor, perhaps we could take the plea and get the interpreter out of here, because I think Mr. Schuster's might take a little bit longer.
Oh, I mean,
We're going to pass on Mr. Schuster's matter and take.
I'm done. So, I mean, is there anything
You're
else?
not done. You're not done, Mr. Schuster. You're going to stay on the line. We're going to take this plea so that we can get Mr. Interpreter out of here. And then
Okay. You wanted to talk with the other one. Okay. Yeah. I can wait for them to finish so that we can finish this up.
Let's do that.
He's going to sing.
This is Jose Partida Garcia, 4A0543-772.
Figured
This is el caso de José Partida García, el número del caso. Can you repeat the case number, Your Honor? I don't have it in front of me. It's pretty long.
Yep, 4A054-3772.
Y el número del caso 4A054-3772.
Is this a change of plea?
¿Eso es un cambio de declaración?
Yes, Your Honor.
Sí, su señoría. And the interpreter of record, Your Honor, for the record?
Yes, go ahead, Mr.
The interpreter of record, Anthony Basler, Washington State certified Spanish interpreter, permanently sworn, with record on file at the AOC. Y su señoría, si puedo, y el intérprete oficial se llama Anthony C. Basler, acreditado en el estado de Washington, juramentado permanentemente con actas de lo mismo en los tribunales del estado.
It should be coming over the email, Your Honor. It was sent just a few moments ago.
Debe de recibir, su señoría, el papeleo del acuerdo declaratorio se acabó de mandar hace un par de minutos.
I can tell the court that it's going to be a city's motion to amend the charge to reckless driving.
Yo le puedo informar que va a ser un pedimento de la Fiscalía para enmendar el cargo a conducción temeraria.
From the charge of driving under the influence.
Desde el cargo de manejando bajo la influencia.
So hello, Ms. Partida Garcia. Thanks for waiting.
Y saludo, señor García, a Partida. Gracias por estar esperando.
Go ahead, Ms. McDowell.
Diga, señora McDonald.
Yes, Your Honor. The city took into consideration the NSP evaluation.
Sí, su señoría, la Fiscalía tomó bajo consideración la evaluación, lo que llaman en siglas inglés NSP.
And lack of history.
Y falta de historial.
We do believe that this is an appropriate resolution, and we would ask that the court allow the plea to go forward.
Sí, creemos que eso es una resolución apropiada y sí le pedimos a su señoría para seguir adelante con el caso.
I will accept the amendment to reckless driving.
Sí, voy a aceptar la enmienda a conducción temeraria.
Are you waiving formal arraignment on the reckless driving, Ms. Ebert?
Señora Ebert, usted está renunciando a una lectura de cargos formal para el cargo de conducción temeraria, señora Ebert.
Yes, Your Honor. No objection to the amendment.
Sí, su señoría, no me opongo a la enmienda.
I'm happy to proceed with the colloquy if you like, Your Honor. Up to you.
Go ahead.
Estoy feliz para proceder con el discurso. Si quisiera, siga.
Mr. Partida Garcia, did we go over this plea form in its entirety?
There's the plea form, all the information. More. It's a long form, 8 pages. It brings joy to my heart knowing that our pro se guy has to sit there and wait through this. Okay, here we go. He's back. Here we go. Let's see when he comes back. I want to see his face here.
Ms. McDonald, would you have any objection to me finding the failure to appear today, but sending a summons? Given the
I would ask for.
What? Failure to appear? Did he not come back? Here we go.
757616. This was set today for a readiness hearing at 2 p.m. Mr. Arief does not appear in person or on the Zoom.
It's not our guy.
Ms. Ebert, do you have any information for the court?
I do not, Your Honor.
Looks like this is the first failure to appear on this case.
He's generally pretty good about it.
Ms.
Our guy's
McDonald,
gonna
would you
pop
have
in.
any objection to me finding the failure to appear today, but sending a summons? Given the,
Your Honor, I would ask for a warrant. Mr. Arief is very well aware of today's hearing, and it's a trial readiness. This was a pretty egregious assault on a stranger assault outside of the Albertsons, where she's indicated that her jaw was dislocated as a result. So the fact that he's not here at readiness is concerning. He does have some warrant history, so city would ask that the court issue a warrant in the amount of $3,000.
yep. Failure to appear found. Court is going to issue a $3,000 warrant.
So if he has, if Mr. Garcia has questions, Kat will have to connect everybody into a room with the Spanish interpreter questions.
Did you hear that, Ms. Ebert?
You want us all in a breakout room?
If he has questions.
If he's got questions.
Si tiene preguntas, puede entrar a un cuarto virtual si tiene preguntas sobre el papeleo que le van a dar.
I mean, him right now, he's got it right there.
Ya se lo doy ahorita, ya lo tiene ahí, ¿eh?
Okay. And Ms. Ebert, I do want to address Mr. Goodwin again before
The translator leaves.
Or on the Zoom.
And the translator leaves. Where's our guy? Comes back here. Waiting. Now they come back. Have to skip all these breaks.
Thank you for that, Your Honor.
Yes. You ready to go back on the record on Mr. Schuster's case?
I think so.
Oh, we're ready.
So this again is Jonathan Schuster, 4A0525748.
Yes, I am here.
Making a
So when we last left off, we were, I believe, setting this for trial next week.
Yeah. I did want to clarify some things from earlier, if that's okay with you, ma'am.
Okay.
Because you had denied both of the motions, and I just want to make sure I understand correctly why they were denied. So would you be able to repeat that, please?
So again, as I stated before, your motion to dismiss is based on an allegation that this court does not have jurisdiction over driving offenses based on the right to travel articulated under the federal and state constitutions. The federal and state constitutions do not limit the states and municipalities' rights to impose traffic laws or driving requirements such as driving licenses and things like that. So there's no federal preemption of these laws. They are appropriately codified and appropriately enforced in the city of Lake Forest Park. So there is subject matter jurisdiction that this court has based on the fact that these offenses are alleged to have occurred in the city of Lake Forest Park. There's subject matter jurisdiction because this court is authorized by statute to function and to enforce these laws. And so for those reasons, your motion to dismiss is denied.
Okay. And so essentially, it's because they don't limit the state municipalities' ability to impose driving statutes. Is that correct?
Yes, you've cited the right to travel broadly articulated in the federal Constitution. But nothing about that is contradictory to Washington's right to impose driving licensing requirements, and nothing about that federal constitutional law prohibits the city of Lake Forest Park from enforcing traffic regulations.
Okay. So it was denied because they do not limit the state's municipalities' ability to impose driving regulations.
So this court does have subject matter jurisdiction. We will be going forward unless you want to enter a guilty plea today with a trial next week. Is this going to be a bench or a jury trial?
Jury for sure. He wants a jury.
Oh, a jury trial for sure.
Yeah, for sure. For sure.
So we will set this for a jury trial next week. Again, Mr. Schuster, discovery will be available to you at the counter at the courthouse after 10 a.m. on Friday. It is the court's expectation that if you want to review that prior to trial, that you come down here and pick it up. There's not going to be a third mailing of discovery to a new address. The court's not going to entertain next week any kind of arguments for continuances based on you not coming down here or having someone come down here and pick that up. Ms. McDonald's not going to keep mailing things to different places.
Would the court setting an intervening pretrial for Monday as well?
We can certainly do that. We can set a pretrial hearing for Monday.
I won't be able to attend on Monday. Tuesday would be the soonest I'd be able to make it to court.
I would ask for Monday, and I would ask that it be in person, Your Honor. So that we can make sure that he's had the opportunity to review the discovery, and we can have those assurances prior to calling in a jury.
I am going to require you to be in court on Monday morning, Mr. Schuster, 9 a.m. in person.
I don't have the ability to make it on Monday, ma'am.
Why is that?
Well, first, I do have other obligations with work. Outside of that, I had set up transportation to make it up there because, as you both know, I don't drive. And so I had set up transportation for Tuesday specifically to make sure I'd be able to attend that. And so I have no problem attending on Tuesday. I just don't have the ability to physically get there on Monday. Plus I have to work. Obviously, work isn't the main thing, but
I'm an Uber driver, right?
I just physically don't have the ability to make it there on Monday.
Then we'll set this for Tuesday. Is the court's expectation that you're going to come pick up the discovery? We're not going to entertain continuance motions based on not picking up the discovery.
Of course.
Well, Your Honor, and the other reason that I'm asking that we set it for Monday and that he be required to come is we also have the Goodwin matter that we are still anticipating will be set for trial that week as well. And by then we're going to have a lot more information. And I do want to ensure before we walk through the door on Tuesday morning to start trial that Mr. Schuster is prepared.
Ma'am, I'm ready outside of the warrant that was brought to my attention today. But during the recess, I actually had a chance to fill out the forms on the Seattle Municipal Court site. So
I'm more concerned about the discovery and the body worn camera. And
since prior to the recess, I am 100% ready for Tuesday at 9 a.m.
I got ready for court during the break.
My concern is McDonald is, to his point, if he doesn't have transportation, I'm not going to ask him to drive here.
Then at the very least, do one via Zoom. I'd prefer it to be in person, but I do think that we need to have.
If you need me here on Zoom, I can definitely do Zoom. That's okay with me. I just physically can't be there on Monday.
Okay. Then that's what we'll do. We'll set a pretrial hearing for Monday. You are authorized to appear on Zoom on Monday, but on Tuesday you are ordered to appear in person.
Okay, and so this went from a readiness back to a pretrial, correct? And then Tuesday we go to trial?
Yes. So today was the readiness hearing. We're going to set a pretrial on Monday, and on Tuesday will be trial.
Okay. Okay. And then
when we address subject,
other than that, Did you have anything else for me?
Anything else you need to address today, Ms. McDonald?
No, Your Honor, I was just double checking my officers. I think we're good on availability, so.
You said what now? Your offices were good on availability?
My officers, the witnesses that are going to testify?
Oh, gotcha.
The ones you're going to cross-examine.
It was Carlsbad, I think, or something like that. Either way.
They're all listed in the report.
Gotcha.
And again, Mr.
She
Schuster,
got
the
mailed to you
conditions
twice.
of release in the meantime are that you make all of your court appearances, notify the court of any address changes within 24 hours, no criminal law violations, no driving without a license and insurance. I do expect you to address that Seattle Municipal Court warrant. I'm not sure if they'll be able to clear it by next week, but at the very least, there should be a docket entry indicating that you've set up a hearing to do so, and all other previously imposed conditions remain.
Are you familiar with Seattle Municipal at all, ma'am?
Yes, I am.
Because when I went to the website regarding warrants, there was a form for motions to quash warrants.
Mm-hmm.
Do you know anything about that?
I know that some warrants can be quashed administratively and some warrants you have to show up in person.
Well, just in terms of the process and how to make sure it's handled correctly. Because when I was on the site, essentially what I was getting, I just filled out the form and then submitted it. And then it sent me an email telling me that I would need to wait for contact. Does that sound correct to what you know?
The court normally will contact you to tell you if they can administratively quash the warrant or if they need to set a hearing. However, given the quick turnaround, I recommend you call them tomorrow and talk to someone at the clerk's office in person.
Oh, that's good advice. Thank you.
Okay.
Great advice.
Okay. Well, there's nothing else on my end. Was there anything with you two?
Don't believe there's anything else today.
Okay. So Monday, 9 a.m., correct?
Monday, 9 a.m. Zoom is okay. Tuesday, 9 a.m. in person.
All right. I shall see you Monday. Thank you.
Have a good day.
You too. Bye-bye now.
Bye-bye. Bye-bye.
So returning to Mr. Goodwin for a 0643.
We're not going to return to Mr. Goodwin. I'm asking honestly, how do people like that operate? Like on a day-to-day basis, how do they live their life? I just can't see it. What do we do? Do we send them an email, say we'd like to have you on the show? We're actually really curious as to if you really think like this or it's just for show. What time is it? What time do you have? Oh, it's 1 o'clock. Why do you guys tell me it's time for lunch? No wonder I'm so hungry. Man, the day's just flying by. It's definitely lunchtime. Let's see. Judge Bernie's still doing his random calendars. When are we going to break for lunch? Right now. It's time for lunch. It's time for lunch. All right, time for a post office box run. Yes, it will be a quick time for a post office box run. I am frustrated. I know things are happening with Karen Reed. Hang on one second. I got Nosy Rosie here. Just 1 second. Hey, Nosy Rosie. Oh, you're not on there. I can hear you. They can't hear. They can only hear me. Okay. Yeah. Let me look. I'll do that right now, okay? All right, you send it to the burner phone or the email? Okay, all right. Thanks, Nosy Rosie. Appreciate it. Bye. Nosy Rosie's trying to get me some documents in the Karen Reed case. Some new ones that posted. Let me see if I can pull them up here. Waiting. Now, what is wrong with the internet today? This is crazy. Who has the internet? Whose job is it? Whose job is it to maintain everything today? I'm not, Nosy Rosie, they have not come through. So I can't do anything. What is wrong with the internet? Trying again. We're on Wi-Fi now. I'm trying without Wi-Fi. Let's see. Oh, thank you, Amber. Send it to, here we go. Amber, appreciate that. All right, we have a document. I'm going to read it off my phone. Can you guys see me? You can, okay. I've already got it, Amber. I've already got it. Thank you. I got it from Mod Chat. All right, Karen Reed, order regarding media, protocol, and coverage. The guarantee of public trial, grounded in democratic values of public accountability and openness, serves as a safeguard against attempts to employ our courts as instruments of persecution. Today, a trial is made public through live broadcast from registered media members who are regularly engaged in the reporting and publishing of news or information about matters of public interest. While maximum freedom must be allowed to the press in carrying on this important function in a democratic society, its exercise must necessarily be subject to the maintenance of absolute fairness in the judicial process. In order to ensure the safety and well-being of all trial participants, the defendant's right to a fair trial by an impartial jury, conformity with Supreme Judicial Court Rule 1.19, and the dignity of the proceedings, the court enters the following orders regarding media and journalist coverage of the above referenced case. Oh, careful, careful. Walk right into that First Amendment issue. Media representatives, reporters, journalists, and anyone else claiming status as a journalist under Rule 1.19 shall be required to sign in every day in a manner prescribed by the clerk of court and show proof of registration with the Supreme Judicial Court Public Information Office. There shall be a designated seating area for media. Any journalist registered with the Supreme Judicial Court under Rule 119 seeking access to broadcast or photographic or audio material for broadcast, streaming, or posting on the internet must coordinate their request and access through the designated media pool representative in accordance with Rule 1.19. Filming, streaming, photographing, recording, transmission, or broadcast of any court proceedings shall occur only through pool arrangements in accordance with Rule 119. The court shall permit one stationary mechanical silent television broadcast or streaming camera and one still photography camera during the trial. Pool cameras and camera operators shall be in place to the start of the session and shall not be dismantled while the court is in session. The camera operator and other members of the media pool shall not interrupt court proceedings with technical problems. Don't have problems. Filming, streaming, photographing, recording, transmission, or broadcast of any kind shall not take place until the court is called into session, when the judge enters the courtroom and takes the bench, and shall immediately cease during court recess upon adjournment each day. Except as permitted, in number 1 and 2, no person is permitted to film, photograph, record, and stream, transmit, or broadcast court proceedings at any time through photographic or electronic recording devices, including still or video camera, cell phones, smartphones, tablets, laptops, audio recording or transmitting devices, or any other electronic device with communication capabilities. Except as permitted in numbers 1 and 2, no person is permitted to use any recording electronic device with communication capabilities to submit updates to social media during the proceedings. This is all courtroom decorum stuff. This is if you're in court broadcasting. In accordance with Rule 119.2b, no person is permitted to record, transmit, or broadcast sidebar conversations between the judge and counsel, conferences between counsel and conferences between counsel and the defendant at any time. The pool camera operator shall pause or disengage the audio component of the pool camera during sidebar conferences. All microphones shall be shut off during sidebar conferences. The pool camera operator shall not manipulate the court the camera zoom and focus as to reveal, accidentally or otherwise, documents of attorneys, the clerk of the court, or the judge, or any other documents not admitted as trial exhibits or not published to the jury. She means documents by the attorneys, documents by the clerk of the court, documents of the judge, or any other documents not admitted as trial exhibits and not published to the jury. That's standard. Media requests for inspection or copies of trial exhibits shall be made on a form in a manner prescribed by the clerk of the court. The clerk's office shall make reasonable efforts to accommodate such requests in a timely manner, subject to court operations. Original trial exhibits shall remain the custody or under the control of the clerk at all times. In accordance with Rule 119.2b, the court prohibits the filming or photographing of any juror or prospective juror at any time, including during court proceedings at any court conducted view. No person shall contact, follow, interview, or communicate in any way with a juror prior to the discharge of the jury, or otherwise harass or tamper with a juror. You pretty much have to know who they are to know who you're not allowed to film. So if you're media, you definitely can't do that. If you know that they are a juror in the case and you try to harass them or film them or something else, that applies to you. Jury impanelment shall commence on April 1st, 9:30 in the first session courtroom, Norfolk Superior Court. The court will permit single pool film camera and a single pool still camera for the first session of the impanelment process, placing the defendant at bar, introducing the case and preliminary instructions to jurors. The camera shall be focused on only the judge, clerk, defendant, and attorneys and shall not film or photograph any prospective juror. When the court recesses after the introduction of the case, all cameras shall be turned off during the remainder of the impanelment process. Media representatives, journalists, and public at large may observe, but shall not record or broadcast the subsequent individual voir dire proceedings. No cameras or recording devices shall be permitted on successive days of impanelment. All persons subject to this order, including all media representatives, reporters, and journalists, are prohibited from interviewing or attempting to interview any person in the courtroom or courthouse. You can't do interviews in the courtroom or courthouse. That's standard. No person shall interview with the intent to relay, transmit, or dispute publicly the contents of that interview or any other person in the courtroom or courthouse. You have to do it outside. Okay? They don't like you setting up your studio in the court. The court prohibits any person from taking photographs, filming, recording, or broadcasting events occurring outside the courtroom in other areas of the courthouse. So no cameras out in the hallways either. Court officers or court personnel are authorized by this order to secure any area which they deem necessary or appropriate to ensure the proper operation of court proceedings and the well-being of the personal privacy of jurors, and a violation of any of the provisions of this order may constitute contempt of court. Court officers may eject or exclude entry to any persons believed to have violated any provision of this order. So this is actually a pretty standard. It's a fairly standard decorum order for media. So the order regarding media protocol and coverage, they basically say you have to register as media if you want to be part of the pool. That means if you want to physically connect your device to the splitter where all that comes out, you've got to register. And if you register, you've got to show that you registered with all the methods that they do in Massachusetts. And then you also have to comply with these rules. There's only going to be one camera. There's going to be one still camera, and everybody gets access to those in the pool. And then from there, you're allowed as media members to broadcast that. So Law and Crime, Court TV, NBC 10, everybody who is there is going to then broadcast that back out. No one who is there is allowed to use their own phone, even if you're a media representative, even if you're like, hey, I'm with, NBC 10. I've brought my own little camera and I'm going to film. I'm going to broadcast that, or I'm going to live tweet from the courtroom. That's where the rules come in. This is not anything different than anything we've had all along. Let's see. So nothing new. But this is, I will tell you that those documents, the decorum for media order is something that we look at every single time you go to court. Every time we try to get in a courtroom, register as media, and every time there might be something in there that's different. You might have a little line in there that says, and the judge requires that everything is on a 30-minute delay. Well, then you have to do a 30-minute delay. Or he says, the judge requires that that you show your badge at all times and you stay in this little area. He can do that. Every court's a little bit different, so you have to follow the rules. Menendez is holding a press conference. Josh Ritter is there right now. Where can we watch the Schuster hearing and trial? I found him in the court docs, but that's it. If they live stream it, it'll show up on the web. If not, you'd have to be there in person. And it's up in Washington, so it's a little ways away from me. I'm on the other side of the country. The order from Judge Bev has absolutely nothing to do with commentators who are following the trial and using it under fair use, providing additional value, insight, analysis, commentary, and that's the same as always. She's not cracking down on the First Amendment. Bev wants filters. Must use filters. Reverend Beasy says, okay, I've been to studios at 30 Rock, and RA's setup is starting to look like a full-blown news broadcast room. This is part of my setup. The box that's over there, not the red one, but the one in back of it, that's the fun one. That's the audio box that really gets exciting. All right. Ronnie's getting a jury summons in the mail today. That's great. It's lunchtime, guys. I'm like shaking because I'm so hungry. I have had like nothing to eat. Let's stop that recording. Don't need that. I have nothing to eat. I have not been able to surf on X all day long for some reason because it's down for me. And I want to know why it's not down for other people if it's down for me. Look, I can't update. I swipe and swipe and swipe, and it stays on the same ad for somebody's shirt that says, sorry, can't, horses, bye. It's a nice shirt, but nothing. Plus, it's really 213. What? No, it's 113. We jumped forward an hour. Your X is down too. I can tell you one thing. Elon is mad right now. Elon's mad. The outage is all over. Is it more than just Twitter? I'm sovereign. You're not on X. X won't do anything for me. Some people argue that it never did. All right. We're going to go to lunch. I'm going to run to the post office. Apparently there's something waiting for me that I have to open on air from Amber. We'll do that this afternoon. And I don't know why. Nebraska says my ex is back up. RA's going to come in. Why are you talking about your ex? I don't have an ex. Tonight, when you go home, please hug the people you love. Smile at someone to make their day just a little bit better. And please stay safe till we go live again right after lunch with an exciting package opening from Amber. I'll use the knife. And open it. We'll see what happens. Guys, have a great lunch. We'll see you in the afternoon. Bye-bye.